People requesting to practice under 8.120 under the supervision of Haley Fortuna Gill and Randy Berman.
Good morning, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant Tony Austin, who is appearing separately by video.
Yeah, your motion is granted. Today was a date that was scheduled for a probable cause conference. Looks like this matter is scheduled for preliminary examination on February 6th at 8:30. Are we continuing to examine this time?
Your Honor, at this time, yes, we will be continuing to examine, though there is an offer that's been extended. It's a global resolution. He has a case out in 54B, a felony that he needs to be arraigned on, that we have an offer on that too, that he is very well considering. So we'll try to work on that in the meantime.
So we scheduled again next week at 8:30, and you'll advise if witnesses don't need to appear.
Yes.
Okay. Any additional matters for the record?
Not from the people.
Your Honor, he did want me to respond. Thank you, Your Honor. Mr. Austin cannot afford the bond. He has a residence on Washtenaw that he can be released to. His cousin lives there. He has medical issues. He was injured his arm when he was arrested, and he's losing feeling in it. So, Your Honor, he explains that he can follow the court's orders. I know there was a failure to appear. And so that does raise the possibilities of flight risk. So, but we just asked the court to consider giving him a first or cognizant bond. Thank you.
People will defer to the court's discretion regarding bond.
Had an address on Washtenaw when he was originally arraigned in December, but that wasn't what he reported when he saw the magistrate a week ago. He said he was homeless and had no phone. So even after that address, he used homelessness as the reason why he failed to appear. So I think the bond is more than appropriate under the circumstances, which is $300 cash surety. So you can get back to him.
Thank you, Your Honor.
Bond will continue. You're all set. You're all set, Mr. Austin.
Yes,
On the record in the matter of the state of Michigan versus Eduardo Alejo, 26-00198. Appearance, please.
Anna Buckingham for the people.
Jacob Riley on behalf of Mr. Alejo, who is appearing from County Jail.
Okay, Mr. Alejo. Mr. Alejo was scheduled for a probable cause conference today for home invasion third. Looks like he has a preliminary examination February 6th at 8:30. Are we continuing to examine?
Well, yes, Your Honor, we are continuing to examine. There is a plea offer which I was able to relate to my client this morning, but he It's not making a decision at this time.
What's the offer?
The offer is misdemeanor entry without permission from owner, malicious destruction of property, 200 to 1,000, and an agreement to pay restitution for the cost of the door, receipt to be provided. We're awaiting that from the victim.
Saying this is instruction of.
200 to 1,000.
So adding account.
Yes.
You know, we noted, we'll see him next week, February 6th at 8:30 in the morning. A bond was set at 2,010%. That will continue, and a no contact order. Any additional matters for the record?
Not from the people.
No, Your Honor.
Thank you. You're all set, Mr. Alejo. That's Ms. Robinson.
Sorry.
Her cases are being covered by Mr. Rowley.
Okay.
Donnelly.
On the record in the matter of the state of Michigan versus Robin Holstein. Holstein on yet?
No, they have not put her on.
Oh, okay. Sounds good. We'll move on. Let's see. State of Michigan versus Jordan Pierce, 23-02860. Appearance, please.
Hannah Buckingham for the people.
Jacob Riley on behalf of Mr. Pierce, present to my right.
Mr. Pierce was scheduled for a probable cause conference for carrying a concealed weapon. And there's an exam next week at 8:30. Are we going to run an exam next week?
I guess you're going to leave the set for next week.
So you need to appear in person February 6th at 8:30. Okay, sir? Do you have any questions at this time? Any additional matters for the record?
No, Your Honor.
You're all set, sir. Someone covering for Mr. Etheridge?
He's on Zoom. He's talking to,
Bailey?
yes.
Okay. And who's in post stories?
I'm not sure. Just put your name in there.
Put your name in the jail post 3.
Evans,
I think
first time.
LaPriest Evans.
Are we ready on him?
Sure. I don't know if he's gonna ask to talk to me. We just got the report late yesterday, so I haven't reviewed it with him, but I can stipulate to it.
I couldn't hear that, nothing he said.
On the record in the matter of the people of the state of Michigan versus LaPriest Evans, this is file number 25-02611 FY. Appearance, please.
Hannah Buckingham for the people.
Thank you, Your Honor. Robert Palmer on behalf of Mr. LaPriest Evans, who appears today via Polycom from the Union County Jail.
Mr. Evans, today was the date scheduled for a hearing on a competency report that the court did receive. Which it was dated for January 22nd, 2026. Counsel, you both got a copy of the report, correct?
Yes, Your Honor.
Yes, Your Honor.
In my understanding, Mr. Palmer, you got the report late last night, so you've not yet had an opportunity to speak with your client.
That's correct, Judge. We got it yesterday, and I know they sent it, I think it was yesterday. Ms. Nash said it. It might have been 2 days ago. I can't recall for sure, but
We got it yesterday.
yesterday. Okay, then it was yesterday. So I have not had an opportunity to discuss it with my client. My intention is to stipulate it, given that it stipulate to the report, given that finds him competent, and ask the court to set a preliminary examination.
Any objection?
No, Your Honor.
The court will enter an order adopting the competency findings, and this report will be incorporated into the court file, and the matter will be set for next action on the docket.
And February 12th at 9:30.
February 12th at 9:30 for exam, okay?
Thank you.
No problem. Mr. Evans, did you have any questions for the court at this time?
No, I'd like to know if I can get my bond reinstated.
You want to know if you can have what?
That was, he wants to discuss bond, Judge.
I think he does have one.
Judge, this was a weird one when, and I can tell the court a little bit about this. Mr. Evans and I he was originally scheduled for a forensic review. He was out of custody at the time. He's originally scheduled for a forensic review. And somehow, and to be clear, I don't think this was Mr. Evans's fault. Somehow I got a phone call from the forensic center saying that he missed it, even though my office never received notice from the forensic center that he had an appointment. And then the court had some concerns about Mr. Evans, potentially showing up late, or not potentially, but showing up late for court. I think at that time, the court, unless my notes are incorrect here, the court remanded him pending that evaluation. He does, in full disclosure, also have a bond violation pending, which I think is part of the issue. He had a drive-through of the GPS tether exclusion zone, was the allegation in the pending bond matter. I will say, for what it's worth, when he was out of custody, he was always showing up for court, sometimes late because he's not got rides easily, but he did always show up. He even showed up late on the day he got remanded, but he showed up.
I'm not sure how your office didn't get notice of the evaluation date, because our office got a notice in September that he was scheduled for December 11th.
And I think
There's a mix up because I heard it was December 1st. They told me it was December 1st. Now, how can it be 2 or 3 different days? First, it was the first. He
Oh,
told
but
me.
I don't know what you're talking about, sir. I know
Well,
that we
he
received
told me
notice.
that there was
I
a- there was
don't,
a
I know that we
competency
received,
evaluation.
I know that we received notice, and on September 11th, that you were going to have a,
I didn't receive any notice of that.
why are you talking when I'm talking?
I'm just telling you, I didn't receive.
Why are you
any
talking
notice.
when I'm talking? Why are you talking when I'm talking?
Because I had that right.
Well, be quiet while I talk, and don't cut me off anymore. So we received notice back in September that you were scheduled for a competency evaluation in December. Whether it was the 1st or the 11th really is not germane to the issue, that you failed to appear, and we had notice. So I don't understand how we had notice, but you didn't have notice.
It was the lawyer's fault. It was not my fault. If I didn't get notice of it, how could I be there?
That's my concern. How did the court get notice and you didn't get notice? And I wasn't even talking to you. I was talking to your attorney. So why don't you be quiet so the attorney and I can work that out, okay?
I'm getting held.
Excuse me, I'm gonna ask you to be quiet one more time. I'm gonna ask you to be quiet one more time before I find you in contempt.
You can do whatever you want. I'm letting you know.
All right,
what the
you're
facts
in
are.
contempt, 93 days, Ingham County Jail. I'm not gonna go back and forth in the court trying to figure out why you didn't get notice. I'm trying to have a conversation with an attorney on the record. I don't have time for this. So you're remanded. We'll see you next week, okay? Or at your next court date. Bye.
Thank you, Judge.
Thank you. You have to restart your computer. February 12th.
Yes. I think you're right.
Letter, will be requesting an adjournment for mental health board resolution if you want to go on record for that.
They didn't put whole Steve on, correct? That might be Holstein. What's your name?
Holstein,
Repeat that again.
Holstein,
It's like every other,
I believe that is.
Robin.
every other syllable. Or no? Okay, on the record in the matter of the state of Michigan versus Robin Holstein, 26-00166. Appearance, please.
Anna Buckingham for the people.
Jacob Riley on behalf of Ms. Holstein, in place of her attorney, Aaron Robinson.
Okay, Ms. Holstein was scheduled for probable cause conference. This is for assault with a dangerous weapon and an aggravated domestic violence. It's my understanding that she's gonna undergo screening for mental health care.
That's correct, Your Honor. She currently has a case with Judge Hillman, and she is set for a preliminary examination in that case on this upcoming Tuesday, the 3rd. She is currently awaiting to see if she's eligible. Regardless, we do have an offer on the table for this case of 7694A domestic violence. If that examination, we expect that by that time she'll be in mental health court admitted, and if that occurs, then we are hoping to have a global resolution through mental health court.
Mr. Riley.
It is all accurate, Your Honor.
The court's gonna find good cause to go beyond the 21-day timeline so that the screening can happen, and will reset a new probable cause date.
Thank you.
She's not being held on this, though. What is she being held on?
I think she's being held on her case in the other court.
Do you want her bond address on this? Because she's not accruing time.
I would, in that case, I would request some small bond be set in this case.
March 5th at 9. March 5th at 9 will be the new probable cause conference date. Just in case.
You do March 20th at 9:30.
March 20th at 9:30. Bond is admitted to 310% with GPS. Do you have any questions, Ms. Holstein?
Yeah, what's going on?
Your attorney said that you're being screened or going to be screened for mental health court. So the court's gonna reset your matter. The court's found good cause to go beyond the 21 days. That's, you have the right to have your exam for so that you can have the screening. And then I've also amended your bond because right now you're not accruing any time while you're sitting in jail on this file. So I amended your bond to a 310% bond, okay?
I was told the other day that I was approved for mental health court already. I've seen the person the other, I believe it was Monday or Tuesday of this week, and I was told that I was approved for that. And he's gonna represent me on Tuesday as well. And he would be requesting that I was that I would be sent to mental health court.
Okay, sounds good. So we'll let your attorneys work through that, okay, ma'am?
Okay, thank you.
Thank you, you're all set.
Thank you.
You're welcome. And did you have another one, Mr. Riley? Elise Cooper?
Elise Cooper for sentencing. I believe she's downstairs in custody.
Okay, she brought up. On the record in the matter of the state of Michigan versus Kevin Kwasnick, 25-03850. Appearance for the record.
Anna Buckingham for the people.
Good morning, Your Honor. Sherman Abbott on behalf of Mr. Kwasnick. Mr. Kwasnick, please state your name for the record.
Kevin Kwasnick.
Kwasnick was scheduled today for probable cause conference. This is for imprisonment and 2 counts of assault with intent to do great bodily harm and a domestic violence. It looks like this matter is scheduled for an exam February 19th at 9:30. Are we continuing to exam?
Your Honor, it's my understanding that the defendant may be entering into a plea, but I'll defer to defense counsel.
We may be entering what?
Into a plea.
Was there an offer?
There was. It is 1 count of strangulation and 1 count of domestic violence. No objection to sentencing under 7694A. And that would resolve both case files of this and the one at 54B.
1 count strangulation, and we have a police chief.
No, Your Honor.
And what's the other count?
Domestic violence, no objection to 7694A.
Subdue.
Oh, that's correct. Ms. Buckingham, is that true on the count strangulation? No objection to hide on that charge either?
Correct.
And that's correct. In that companion case in 54B, I won't say companion case, but that other matter, case number is 25-1174FY.
Your client wants to accept that offer.
Yes, my client wishes to accept the offer today.
Okay, Mr. Quaznik, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay. Mr. Quaznik, you have the following rights that you would need to understand, and then you would need to give these rights up if you wanted to accept the offer. First, you have the right to the presumption that you are innocent. You are innocent until proven guilty. You have the right to take this matter to trial and have the prosecutor prove each element of each of the charges being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any witness called to testify against you, the right to call your own witnesses to testify on your behalf, the right to present evidence at trial that you believe show a defense to these charges, and the right to remain silent and not have silence be used against you. Do you understand each of those rights, sir?
Yes.
And are you willing to give all of those rights up in order to plead guilty to the count of strangulation? I'm sorry, you said 1 count of what? Strangulation?
Yes, 750.8 for body harm less than murder / strangulation.
What's the maximum penalty?
Maximum penalty for that, Your Honor, is 10 years or $5,000.
That's a felony. It's a felony offer?
Yes, Your Honor.
Well, he can't take it today then.
Okay.
Got a felony offer, it's gotta be, he's either gotta take it at circuit court, or we have to contact circuit court to set up the felony plea, and then we can take it in district court. So how does your client want to proceed?
I mean, if there's no objection to the prosecutor, if it makes it quicker, we'll just take the plea up at circuit court. Unless the prosecutor absolutely needs this deal to be done at district court, then we could obviously either reschedule it for another probable cause conference, or we could wait until you get the authorization.
All right, we have no objection to it occurring in circuit court.
Okay, so you're waiving your exam?
Yes, Your Honor, I've advised my client is right to have a preliminary examination. Obviously, if we're ready to take a plea today, Your Honor, he knows what rights he's waiving, and we're asking this case to be bound over to the circuit court.
Okay, that's correct. So you understand your right to have a preliminary examination, the right to have the prosecutor establish first that they have sufficient probable cause that felonies were committed and probable cause sufficient to charge you as the person who allegedly committed those felonies.
Yes.
No one's threatening you to get you to waive your exam, correct?
No.
Any promises if you waive your exam?
No.
Okay, I find your waiver to be freely and voluntarily made. Your bind over date's gonna be February 11th. That's the date the circuit court is receiving the file from the district court. It's not a date that you have to appear in circuit court, okay?
Yes.
Your next court date will be a pre-trial in circuit court. Your attorney will be made aware of that date, so you'll stay in contact with him, okay?
You have to respond, Kevin.
Okay.
Okay. Thank you, Your Honor. Thank you, Ms. Buckingham.
I didn't go off the record yet.
Sorry.
Bond in this matter is set at 10,000 cash surety. There's a no contact order between you and Mackenzie Kane that will continue, as well as GPS tether. Any additional matters for the record?
Happen people.
None, Your Honor. Sorry, I thought you were done. My apologies.
No worries. Thank you.
Thank you.
You have an interpreter here? That's not good. No, I'm cool. Somebody downstairs? Machado,
Eva Machado.
but no interpreter?
No interpreter. I have nasty. Yeah.
Is Carlos here?
Oh, yeah.
Okay, Mr. Etheridge. Do you have someone on
I
Zoom?
have Bailey on Zoom, Your Honor, from the, from the jail. Probably from the jail.
He was in post two. I don't see him.
Told him to
Oh,
wait.
there he goes.
There you go.
Okay.
Told him to wait in the room.
This is the matter of the state of Michigan versus Daniel Bailey, 26-00160. Appearance, please.
Anna Buckingham for the people.
Attorney Derek Etheridge from the Office of Public Defender on behalf of Mr. Bailey, who is appearing by video from the Union County Jail.
Okay, let's see. Mr. Bailey was scheduled for a probable cause conference today. This is for assault with a deadly weapon. There's also a misdemeanor assault and battery. This is continuing to a exam.
Understanding is we are continuing to the exam. There is an offer from the people, and that would be plea to count 2, assault and battery, dismissal of count 1, felonious assault.
Your Honor, I had the opportunity to review the plea offer with Mr. Bailey at this time. He is considering it. However, he would wish that the court leave this preliminary examination on for next week.
We will see Mr. Bailey in person next week, February 6th at 9 a.m. Do you have any questions for the court, Mr. Bailey? Okay, any additional matters for the record?
Nothing with people.
No, Your Honor, thank you.
You're all set, sir. Let's see, Mr. Are they gonna put Perez on for you? Or
So he was saying that, so he's not in custody. It's a big mix up, I guess, because there's somebody else with the same name, same date, year, but not same date of
We were in the
birth.
same courtroom in Buchanan too. the
Yeah.
other week.
Yeah, they brought him last week too.
So he's not in custody.
My guy was not in custody last week, and I think he's still out of custody.
he's not here?
Oh, it's a little early though.
It's not scheduled at 9:30. Well,
It's
it's
9:33,
9:33 now, but I will
Do you
call.
need to meet privately with your client?
Yes.
Okay.
I will try to follow my client to where he's at, if he's not outside.
Thank you.
That's right.
Okay, so you said it's the same name in year.
And check this out, they went to the same
Yeah,
high
and
school.
I was looking at it with Marquita last week, but she said it was the same person. or not, So.
Exact same person.
They were in the same
Yeah.
class in high school too.
Oh, that's wonderful. And they both got criminal charges at the same time. Like, got it. That's wonderful. Hopefully different charges. So we'll just have to remember to confirm the date. Mr. Bailey, you're free to go.
Pardon?
You're free to go. You can let the deputy know that you're done.
Okay, thank you, Your Honor.
You're welcome. Mr. Boyd was here with Sotelo, or at least Mr. Boyd was here. I don't know if Sotelo was.
Yeah, they're both here. I've seen them. I think that's gonna run, Your Honor.
Oh, that's what I thought.
Still talking about different things right now on that.
I'm not sure. What's your name, sir?
Miguel Perez.
Remove your hat, please.
Yes, ma'am. I'm gonna reposition my phone. Hold on. Second.
No problem. Can you tell me the month and year you were born? Not year, month and date, not the year.
Yeah, it was September 7th.
Thank you. Mr. Etheridge's client.
Yeah.
State of Michigan versus Matthew Weller, 25-03259. Appearance for the record, please.
Hannah Buckingham for the people.
Josh Kuiper on behalf of Weller.
I don't know why I'm getting feedback.
Mr. Eldridge is just trying to call me.
Mr. Etheridge is right here.
Yeah.
Can you just talk to Mr. Etheridge?
Your Honor, my understanding is Ms. Perez is in the process of retaining an attorney on both files. We've already waived the timeline on the original file. On the second file, I'd ask to waive the timeline to get a little more time to get the attorney and ask the court to reset it for a probable cause conference.
Give me just a moment, sir. I actually was on the record with something. Okay, let me just make sure I have the right dates on both birthdays on both. Did you guys fingerprints on this one? One ended in 145.
Yes.
Okay, that's the right one. Let me go off the record on the other one. On the record in the state of Michigan versus Miguel Perez is 26-00154 FY. Appearance, please.
Hannah Buckingham for the people.
Attorney Derek Etheridge for Mr. Perez, Your Honor, is appearing by video. Your Honor, is that the new file or the file I'm already appointed on?
This is the newer file. There was a note from the last court date that the timeline did need to be waived. I do see that you have already had an appearance on 26-0002.
Okay, Your Honor. I just wanted to clarify because Ms. Robinson was originally appointed to the new file and they're in the process of reassigning it to me since I had the older file.
I do see that as well. And you said that he's hiring private counsel?
Yes, Your Honor.
Okay, is that correct, Mr. Perez?
Can you repeat that? I'm sorry.
You're hiring private counsel to represent you on this matter?
Yes, ma'am.
Okay, so you understand that you have the right to have a preliminary examination within 21 days of the date that you were arraigned. You were actually scheduled to have a preliminary examination February 6th at 9:30. That's next week. You understand that?
Yeah, it's next Friday.
Okay,
Right.
I'm gonna treat next Friday as a probable cause conference, so your attorney can appear and tell us what date they want to have your exam.
Okay.
Do you have any questions at this time?
Do I have to have them register with you guys or anything like that? Or I mean,
Yeah,
or they're already
if you hire an attorney, they have to file a substitution of counsel.
a substitution
Just
of
have-
counsel?
Yeah,
Correct.
just have that attorney contact me in order for us to do the paperwork for them to take over your cases.
Okay.
Do you have any questions at this time?
No, ma'am.
We'll see you next week on both files, February 6th, 9:30, okay?
Yes, ma'am. Have a good
Thank
day.
you.
Thank you.
Too.
Thank you, Your Honor.
Thank you.
Thank you,
Okay,
Mr.
back on the
Eldridge.
record,
Yes, sir.
back on the record in the matter with Matthew Weller, 25-03259. Let's see here. Counsel, we already had your appearance. This matter was scheduled for a preliminary examination today. My understanding is there's a request to adjourn. Why are we adjourning?
Yes, Your Honor. The people were contacted by the victim in this case, very last minute, and she is in Florida currently. She is fully on board and willing to proceed and show up for the next court date if the request is granted. But obviously, we are at the mercy of the court regarding the adjournment. If that's not granted, I would like to make the court aware that we would plan on refiling.
I thought I addressed it
that's your one.
yesterday.
Yeah.
I said it could be reset.
Thank you, Your Honor.
Oh, no problem.
I believe that defense
You
counsel
addressed
wanted to
that.
address bond as well.
There was a bond motion or request?
The request, Your Honor, is that the GPS tether be removed. And second, Mr. Weller just obtained a new job, which requires training. I believe it's February 9th in Wisconsin. So we would request those two modifications, that the GPS tether be removed first, and second, that he be permitted to leave the state to Wisconsin for work purposes only. With regard to the GPS tether, there is no known contact between these two parties anymore. My client has moved out of the house he lived in on Cinnamon Lane, and he has no idea of the whereabouts of the former Miss Weller.
It sounds like Ms. Flores in Florida. Well, it sounds like she's in Florida, so I don't think tether is needed at this time. So I will allow him to remove the tether. So he's gotta go back to the county to have that removed, or he can go to JSG and we'll notify them that it was ordered removed. Lastly, there was, you said, training in Wisconsin for how long?
He indicated 3 weeks, Your Honor. Matt, I just became aware of this last night, Your Honor. So Matt, can you give a more full explanation to the judge of what the training entails?
Yes, so it is 3 weeks worth of training, Monday through Friday. I do have the option of coming home on the weekends, but 3 full weeks of training in Wisconsin at their headquarters.
And he's reporting to pretrial services, correct?
Yes.
Okay. Your request to travel for work training is granted, and you'll continue to check in remotely with pretrial services, okay?
Okay, thank you, Your Honor.
March 5th at 9:30.
Does March 5th at 9:30 work for exam?
Yes, it does, Your Honor.
That works, I'm assuming.
Yes, Your Honor, thank you.
Okay, any additional matters for the record?
Not from the people.
Nor from the defense, Your Honor. Thank you.
Thank you, you're all set.
Have a nice week.
Same to
Thank you.
Ms. Donnelly, are you ready with?
With Leyva Machado, yes, Your Honor.
Okay, very good. On the record, in the matter of the state of Michigan versus Yanso Leyva Machado, this is filed with a 25-02747 appearance, please.
Fiona Buckingham for the people.
And we do have an exception, please state your name for the record.
First name Carlos, last name Hernandez.
Assistant Public Defender Sarah Donnelly on behalf of the defendant who is standing to my right.
So you can raise your right hand. You solemnly swear or affirm to interpret in the matter before the court completely and accurately and not divulge confidential communication.
I do.
Thank you. Today was the date set for sentencing. I do have a pre-sentence report that was prepared on the 15th. Counsel, did you get a copy?
Yes, Your Honor.
Yes, we've been provided a copy. I have gone over it with Mr. Leyva Machado, and we have no need for any additions, deletions, or corrections.
For the people, Your Honor. I'm just trying to make sure it's not me. First paragraph, the defendant did not meet any of the required criteria for any type of substance use disorder. Second paragraph. Results overview indicated no evidence of random responding and a high probability of a substance use disorder. So we got some conflicting information. Defendant met 1 out of 11 of the diagnostic criteria for an alcohol use disorder. But they're recommending 8 months probation. You can make allocation.
Thank you, Your Honor. I do see that, and I wonder if it was just written poorly. There was no evidence of random responding and no high probability of a substance use disorder, but Your Honor, yes, after reviewing the report with Mr. Leyva Machado, it does seem that there was an issue with him not complying with the bond conditions. But I don't believe. But I do believe that everything in this report can be factually true if it does appear to be kind of conflicting. The diagnostics reported, questions that he didn't indicate any sort of lying or anything like that, but obviously the language barrier, I believe that the language barrier has resulted in, I mean, obviously, I think even people who speak English will often come to the sentencing having still smoking marijuana. Obviously, they haven't stopped. And so with the language barrier, I think that's even becoming would be more common or tend to that. But after going over with him the report and explaining to him bond conditions, and his probation conditions and anything that you're, and showing him actually what he would have to do, like showing him the MAD VIP website, you know, things like that. I do believe that he well, still a good candidate for probation, Your Honor. I think he will complete it and follow the court's orders. Thank you.
Machado, do you understand that you were not supposed to be drinking alcohol while you're on bond?
Yeah, they did.
Who's they?
The interpreter. He had last time
Told him that he couldn't drink,
es la persona que te dijo que no podía tomar, era el intérprete de la última vez. Correct.
but you reported to probation that you drank before your pre-sentence interview.
Pero usted cuando fue a la aprobación le dijo al oficial que sí estaba tomando. He has not been to probation. He's never been to probation.
He met with a probation officer so that they can prepare this report.
Usted sí se ve como que fue a la aprobación en el piso 5. Yes, he did. He did go to
Okay.
probation here on 5th.
Okay, that was December, back in December?
Correct.
Okay, and you told him that you had drank a week prior?
Y le dijo que tomó como una semana antes de eso. Eso que le dijo usted. Yes, he did report that he was drinking at home with his spouse a week prior.
But you understood that you weren't supposed to be drinking?
Pero el intérprete le dijo que no tenía que estar tomando, entonces, ¿por qué estaba tomando? It was simply stress. It was a weekend that he drank.
Not allowed to drink.
No puedo tomar. Okay, he will stop drinking. He won't drink anymore.
Yeah, if I put you on probation and you drink, that's a violation.
Entonces, si te ponen una aprobación que no puede tomar y toma, es una violación de la aprobación.
I think the concern that I have is the way this report is written. It's unclear to me if he has a problem with alcohol or not.
Bueno, el reporte que pusieron en la aprobación no indica si usted tiene problema con alcohol o no. No, he states that he does not currently have any issues with controlling his drinking or any use of drugs.
Okay, so he doesn't have a problem not drinking for 6 months?
Como si usted no le ponen que no toman por 6 meses, usted puede parar de tomar por 6 meses. Yes.
Yeah, I'm gonna amend the report for the recommendation. I'm gonna put him on probation for 6 months.
Estamos poniendo una palabra. Entonces, en vez de 8 meses, lo van a poner por 6 meses.
He is gonna be ordered to complete some alcohol education programming.
Clase de
He's employed.
tiene trabajo.
It said that he was missing work to attend class. I don't know what that meant.
I did see that, Your Honor. I thought that was maybe there would be maybe difficulty working and attending classes. I believe what's holding him up working is his license.
It says that he's employed full-time at interpreter.
Oh, yeah.
Oh, so I couldn't understand him, but it's saying that he was earning a monthly salary and that he had been employed full-time for 7 months. So he's not working now? You're not working?
No, he's not working right now.
When did you stop working?
¿Cuándo paró tu trabajo?
En septiembre, entró la compañía.
In September, the company closed.
Pero trabajo para Amazon Select,
So currently he is working for Amazon,
pero como no tengo la licencia, no puedo.
but as he doesn't have his license, he's unable to work.
Okay. He's gonna have to obtain employment as part of probation.
I'm sorry, Your Honor. It says here on the pre-sentencing questionnaire, he's attending classes. Is he attending any sort of classes?
¿Está yendo a cualquier tipo de clase ahorita?
No, ninguno.
Okay.
No, he's not going to any sort of class.
Okay.
Yeah, it says that also on the recommendation, that missing work to attend class. Then it sounds like he got a job at Amazon. I don't know what's going on, but he's gonna be required to be employed while on probation.
Conseguir un trabajo.
Do you understand that?
Sí. Yes.
You must attend a victim impact panel within 90 days and provide proof of that.
Entre 90 días, tiene que ir al niño en esta clase que le enseñamos. Tiene que completar eso entre 90 días.
You're not,
Can you take a picture of that?
Yeah. We'll take a picture of it.
we'll give it to you after this, okay? You're not to use alcohol or drugs
No puedes tomar, no puedes hacer ningún tipo de droga.
while on probation.
Está en esta población. 6 meses.
You will be required to do random testing
Se van a hacer pruebas de alcohol y drogas.
for alcohol and drugs. Do you understand that?
Simplemente te van a hacer una prueba de alcohol y drogas.
You're not to engage in any assaultive or threatening behavior. You're not to be at any bars or nightclubs.
No puede ir a pistear, no puede ir a las fiestas, no puede ir
You have any questions?
que van a hacer la agresión. Preguntas de eso.
No, no.
No, but everything's clear. Vamos a llegar al piso 5, hablar con la población. Después que se vaya, quiere ir al secretario de para que esta persona se licencie.
I don't see OWI cost recovery. Is that accurate?
Correct, Your Honor. Actually. See it. Okay, Your Honor, being told that it is a $125 fee to the office. Hingham County Prosecutor's Office.
Nothing for the police though, correct?
Correct.
It's a $30 per month oversight fee for each month of probation. That's 6 months, so it's $180 there. $75 crime victim rights fee. $50 state minimum cost. And then the $125 fee to the prosecutor's office. Total fines $430. And you'll make monthly payments on that. You have any questions at this time?
Not at this time. He apologizes very much for the charge that's against him and it won't happen again.
Thank you. Lastly, you do have the right to request early discharge from probation.
Sí tiene derecho para pedir que salga de la aprobación temprana. Si usted piensa que puede ser temprano.
Once you've completed half of the term that I ordered,
Que le haga mitad de las clases que ella te está diciendo, a mitad, usted puede pedir eso.
so long as you've done all the programming
Más con que haga las clases dentro de esas clases.
and had no violations within those 90 days.
Y si no tiene ningún tipo de violación,
You can get the form to request early discharge from your probation officer,
si quieres observar al piso 5 con la aprobación a su oficial, le puede pedir a él que se lo dé.
or off the court website.
O lo puede hacer por línea en la página del court.
If I set it for a hearing
Si ella te pone otro caso directo para revisar,
to address your request for early discharge,
para a ver su aplicación para ver si puede ser en temprano,
you have the right to hire an attorney to represent you.
usted tiene derecho a tener su propio abogado con usted para discutir ese caso.
But you do not have the right to court appointed counsel for that.
Pero para eso no tiene derecho a tener un abogado público. No tiene derecho.
Do you have any questions?
¿Tiene pregunta de eso? No, not at this time.
Okay, we'll get you down to probation and check in, and then you're all set.
Vamos a llevar la aprobación para y de ahí está listo.
Thank you. Who's in the jail? What's your name?
Bill Perez.
You don't, we don't have.
Yeah, just gotta let them know.
Yeah, you don't have court before Judge Simmons today.
Thank you.
Thank you. I saw, oh, this, what are we doing with Pointer? Are we running an exam on that one too? I just seen them step out. Is that all the PCCs? No. Yeah. Okay, so we have Pointer, Thomas, Simon, is that an exam?
That was, step to adjourn.
That was a step to the journal.
It should be in, because he had a substitution too.
Sir, we are anticipating a plea. We are just speaking to the victim.
Okay, and then we're running some tele. On the record in the matter of the people of the state of Michigan versus Zero Pointer 25-02745, appearance please.
Good morning, Your Honor. Angela Delvero on behalf of the people.
Good morning, Your Honor. Deidre James on behalf of Daryl Pointer, who's standing to my right.
Your Honor, today is the date and time set for preliminary exam in this matter. The parties have come to a resolution. I have just, your staff was nice enough to print off. It's a little bit of a complicated plea agreement, and we just wanted to approach and just go over it with Your Honor. There are some things that are part of a killabrew that frankly, you would likely need to agree to before we even entered into the plea. So we wanted to make sure you were okay with that.
Need to approach?
Yes.
So we have here an offer for the defendant to plead guilty to an added count 2 of aggravated domestic violence, an agreement to 18 months probation, and no charges issued on report from Lansing Police Department 25-06057, and agreement not to prosecute on the PA 52 violation, which is from October 2025, but the court just received it earlier this month. There's also a sentencing agreement, which we call a killabrew, to 18-month probation with terms to apply or comport with family court. Okay, to early relief if done with family court sooner, correct?
That's correct, Your Honor. And for the record, there are some other parts of the plea agreement that I couldn't fit on the plea form, so we typed out a full plea agreement. We're just asking the court to attach that to the plea form. I assume that's what probation didn't get. But yes, essentially what we've done is negotiated a term of probation that will run at the same time that the defendant is doing the programming in family court, and agreed that the classes and things that he's taken in family court can satisfy his probation terms if that meets the approval of Your Honor and your probation department.
Sounds okay. And I did receive the additional paperwork with the terms. Again, I think we've covered number 1, number 2, the agreement to the following mandatory things at probation, in addition to what the court finds to be appropriate at the time of sentencing. The defendant is to be in compliance with all orders, directives, instructions, and recommendations of the CPS and the family court system, and that the defendant must sign a waiver to permit the criminal probation agent to communicate with workers in said CPS, INS, and family court systems and programs. The goal of this is to prevent duplicative orders and to make sure the programs are working together as best as possible. And we've already discussed the last 2. That's your understanding of the plea offer, sir? And you would like to accept that offer? If you could raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? You can put your hand down. Okay, this is an advice of rights. It's the information sheet. Is that your signature? And you've gone over these rights with Ms. James. Do you have any questions about these rights?
No.
You're willing to give these rights up today in order to accept the offer and plead guilty to added count 2 of aggravated domestic violence under the terms and conditions stated on the record?
Yes, ma'am.
So you understand that you have the right to the presumption that you're innocent. So you can maintain your innocence. This matter could proceed to jury trial, and the prosecutor would have to prove each element of the charges being brought against you beyond a reasonable doubt. You understand that?
Yes, ma'am.
You have the right at any trial to cross-examine or question any witness called to testify against you, the right to see I'm sorry, subpoena your own witnesses to testify on your behalf, the right to call or present evidence that you believe show a defense to the charges being brought against you, and the right to remain silent and not have it be used against you. You understand those rights?
Yes, ma'am.
Is there anyone forcing you to get you to give these rights out? Do you feel coerced to enter a guilty plea? Any promises not stated here on the record to get you to enter a guilty plea? Are you currently on probation or on parole? You understand that by pleading guilty, it could result in a conviction that you may need to report to a current employer, or you may need to report this conviction on a future job application. It also could have impact on travel or immigration. So you may want to travel outside the country somewhere, and you could be prevented because of this conviction. Do you understand that? As to the added count 2 of aggravated domestic violence, how do you plead?
Guilty.
Is that because you believe you're guilty?
Yes, ma'am.
Factual basis.
Thank you, Your Honor. Mr. Coroner, I want to take you back to on or about May 19, 2025. Were you at 4702 Birchfield Avenue?
Yes, ma'am.
That's in Ingham County, Lansing?
Yes, ma'am.
Okay, and at that address, were you residing there at the time?
Yes, ma'am.
And your son, Daryl Pointer Jr., was he also residing there?
Yes, ma'am.
And did there come a time when you were verbally arguing at him?
Yes, ma'am.
And you didn't like Daryl Pointer Jr.'s response?
Yes, ma'am.
And you hit him with a belt?
Yes, ma'am.
And did that belt leave 2 marks on his arm?
Yes, ma'am.
You agree that he did not go get medical attention, but he certainly could have
Yes, ma'am.
due to the severity of it.
Yes, ma'am.
And this was not done in self-defense? He didn't hit you?
Oh, no, no, no.
You did it purely because you were angry at his verbal response?
Yes, ma'am.
Does that satisfy the basis, Your Honor?
Any questions from the question?
The people are satisfied that that's a factual basis, frankly, for the child abuse third as well as the aggravated domestic violence. So, yes.
The court satisfied with the factual basis, I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. This matter will be set for sentencing March 27th at 9 o'clock in the morning. When you leave here, you'll go down 1 floor, check in with probation. They will get you scheduled for a pre-sentence interview. And they'll advise the court about how they believe you should be sentenced. I have included the terms and conditions taken into consideration under this plea so that they will have that for reference as well. Do you have any questions at this time?
No, ma'am.
You are free to appear for sentencing via Zoom, so long as you have video and you're in a place appropriate for court. Any additional matters for the record?
Nothing further, Your Honor.
Nothing further, Your Honor. Thank you.
Thank you. You get your sign card?
Yeah.
Oh. Sotelo? Yeah, okay. On the record in the matter of the state of Michigan versus Felipe Sotelo, second, at 25-00926. Yeah.
Morning, Your Honor. Randall Berman on behalf of the people.
Top of the morning, Your Honor. Dwayne Boyd, P79612, on behalf of Felipe Sotelo. Please state your name correct.
Good morning, Judge. Felipe Sotelo.
Okay, today was the date that was scheduled for preliminary examinations for controlled substance delivery causing death. Is there any preliminary matters before we call witnesses?
Your Honor, I assume that there's probably a mutual request to sequester witnesses. I would note that the investigating detective is seated at council table with me. My other witnesses are either out in the hallway or in the jury room. I don't know if there's any other prospective witnesses in the courtroom. Mr. Joining me with that request?
I'm joining.
I'm not sure if there are witnesses in the courtroom. I think you all would know better who's in the courtroom.
I can't think of
Okay.
I don't recognize anyone, Judge.
Sequestration is ordered. Any other preliminary matters?
I do, Your Honor. Just as it pertains, I tried to streamline things and pre-mark my exhibits. So exhibit number 1, Your Honor, is the Sparrow autopsy report, which pursuant to MCL 766.11B is specifically mentioned that autopsy reports are admissible at a prelim. I've already shown all my exhibits to Mr. Boyd, so if I may approach it, unless he has any further objection, I would submit that exhibit 1 is admitted.
No objection.
Thank you. People's ones admitted. Any additional matters?
Yes, Your Honor. As it pertains to People's Exhibit number 2, that is a thumb drive that contains records from T-Mobile and Facebook. And what I did is I had the entire downloads put onto this disk, and we're going to be talking about 1 or 2 pages from each file. The files are very voluminous. So what I did is I put them all onto exhibit number 2 to admit the entire download. And then I marked 2A, 2B, 2C, and so on from that for the specific records that we're going to be talking about. And what I did, Your Honor, is again pursuant to MCL 766.11B, it's a record of regularly conducted activity, and there's a certification for each file. And what I did is I attached the certification to each exhibit that I have. That's how my mind works, so that I can keep it straight and make sure that everything is in order. So People's 2 is just the full download that I'm prepared to tender to the court pursuant to the record of regularly conducted activity that I have attached to each of these separate exhibits. And again, I have shown that all to Mr. Boyd ahead of time.
No objection, Judge. Business records.
2 is admitted.
And then we will go through each of those with the witnesses as needed. And then the other exhibit I have is coming in through a witness. The other 2, yeah. So I think that, Your Honor, is the extent of my preliminary matters. Thank you.
Thank you. Any preliminary matters for you, Mr. Boyd?
No, Judge.
Okay. You can call your witnesses.
Thank you, Your Honor. People call Terry Redding.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
You can have a seat, sir. There's a microphone that's in front of you. That is so that the lady behind you can record everything that's being stated in the courtroom. It will not elevate your voice at all, okay?
Yes.
So keep your voice loud and clear. All of your responses must be verbal. If it's a yes or no, you gotta say yes or no. No head nods, no head shakes, no uhs and ahs, okay?
Yes.
Thank you. Okay. It always happens. We'll just remind you if you forget. We'll ask you if it's a yes or no. If there's an objection from either of the attorneys, you'll stop speaking. I need to make a ruling on that objection, and then I'll tell you if you can give us that answer or not, okay?
Yeah.
State your first and last name and spell both.
Terry L. Redding.
Spell both.
RYREDDING.
Thank you, counsel. You can proceed.
Thank you. Good morning, Mr. Redding.
Morning.
Did you know someone by the name of Claire McCray?
Yes,
How did you know Claire?
she was a friend of mine, and I had met her at the bar she was working at. Probably 2019.
In 2019, is that what you said?
Yeah.
Thank you. I want to turn your attention back to June 1st of 2022. Did you stay on West Howe Avenue?
Yes.
What was the address, full address there?
529 West Howe Avenue.
Did anyone else live at that house with you?
No.
Was anyone with you on June 1st of 2022 at that address?
I had been letting Claire stay there because she had just gotten out of jail.
So Claire was staying at your house
Yes.
at 529 West Howe Avenue?
Yes.
Is that in the city of Lansing, county of Hingham, state of Michigan?
Yes.
In the evening hours of June 1st of 2022, do you recall leaving your home?
Yep. It was around 9 p.m.
And when you left, was Claire at the house?
Yes. I just dropped her off.
So you had just come from somewhere else and dropped her off?
Well, I've been with her all day, trying to help her out, bringing her to different locations and then to her father's house, so she could get her mail.
What time do you think you dropped her back off?
At the house at 9 p.m.
How did she seem to you as far as how she was acting?
She was acting fine, normal, whatever. She had asked me to go to Myers because her mom had just sent her some money from Western Union, so we went to Myers to get the money her mom had just sent her.
And then you dropped her back off at home?
You know, dropping her back off.
So when you say you dropped her off, did you then go somewhere else?
Yes.
Where did you go?
It'd been a long day with her, so I went up to go have a beer at the bar, which closed at 10 o'clock.
Do you recall what bar it was?
Yeah, Center Stage.
You said what?
That's where she was working.
What's the name of
She used
it?
to work. Center Stage. Up State Road,
How long do you think you were at Center Stage?
an hour.
After you left Center Stage, you go home or somewhere else?
Yep, I went back home.
So this, my math is correct, about 10 o'clock?
Yes.
Just, when you went back home, did you go in your house?
Yeah.
Anything unusual that you saw when you went back in the house?
No. I was talking to her mom on the phone.
When you say her mom, do you mean
Claire's mom.
was Claire in the house?
Yes.
Did you talk to Claire?
No,
Why is that?
she was already dead. Whoever was there had a short window for her to be there. No one even was supposed to know she was there. The only person that she had contacted was somebody to bring her
Objection.
drugs.
What's the objection?
Speculation.
You want to respond?
Yeah, I'm gonna agree and I'm gonna,
You said there wasn't even a question. but
yeah,
that's
so
okay.
I'm gonna walk the
Thank you.
witness through it. Thank you.
Objection
so-
sustained.
You stated that when you got back home, you didn't talk to Claire because she was already dead. Did you see her somewhere in the house?
In the apartment that I was letting her stay in,
What room was she in?
the living room.
And when you came in, can you describe for us, please, what it is that you saw?
It looked like she was in the process of being raped
And why would you say that?
because of the way her clothes were off her body and the way that her clothes were pulled.
You said clothes are off her body. Can you
Yeah.
describe for us, please, what that means?
I'm a professional dresser at the Wharton Center, Michigan State, for Broadway shows.
Okay.
And she was wearing a sweater, an Under Armour top, and a bra that were all pulled off her body like someone had taken their thumbs, gone straight up, pulled them off her arms, going up, and then threw them on the counter because they were all balled together like when we're setting out clothes for people to put stuff on,
All right,
if they need to do it quickly.
okay, let me just stop you there. You stated that her clothes were balled up on the counter and that was the top portion, her shirt and bra.
Yeah.
What about her pants? You notice anything about her pants?
They were pulled down to her ankles. And they were still up.
Was Claire upright on the ground or something
No,
else?
her face was planted in the couch and her butt was sticking in the air.
Did you try talking to her?
I was on the phone with her mom. First thing I said was, I just found Claire, hung up. I called, well, I didn't know she was dead, of course. I mean, I didn't know.
Okay, so what did you do next?
I went to her and I laid her on the ground, on the floor. And I'm not familiar with heroin addicts. And there was an overwhelming sound of water running out of, someone told me it comes out of their lungs. When I laid it down, it just sounded like pouring water.
Did she respond to you at all?
No.
What did
She
you do
looked like
next?
she was already stiff. Rigor mortis had already kind of started setting in.
Objection. This witness is not qualified to talk about rigor mortis.
Well, maybe he is. He's a professional dresser. Maybe he has some medical background. I don't know.
She was.
Did you want to respond to the
You
objection?
can strike that part of the answer and I'll just follow up. You indicated,
Stricken.
you stated she was stiff at that
She
point?
was very stiff.
Okay.
It was hard to try to open her eyes. It was tough to move her.
At any
She
point,
had extreme purple veins sticking out of her face and her.
did you at any point call someone for help?
I called 911.
And did you see anything in the room near her body that was out of the ordinary for your house?
I don't know what that means.
Anything out of place, anything that you normally don't see in your house or anything missing,
Well,
that
there
type of
was
thing?
no, when on the dresser, there was a packet, paper packet with the plastic, it was sealed with plastic. And it looked like it was EMT training day, because there was 6 EMT people that walked in the place. And it was missing when they left.
Objection.
And
Hold
police
on,
officer
hold
never
on one
noticed.
second. Hold on.
Mayor Tidd.
Objection sustained.
Okay, you said that there was a packet, you said on the dresser,
Yes,
and you said it was sealed, it was paper but sealed in plastic.
correct.
And then was it collected or at some point did you not see it?
It just came up missing after the EMT people left.
Thank you. No further questions, Your Honor. Thank you.
Cross-examination.
Yes, Judge. Mr. Redding, you and Ms. McCray had spent the evening together, correct?
What did you say?
You and Ms. McCray had spent the evening together, correct?
What do you mean evening? I've never had any relationship with.
Let him answer or clarify the question for you.
Spent time with Ms. McCray that evening, correct?
During that day, yes.
At about what time during that day did you begin spending time with Ms. McCray?
Maybe noon.
Had you been with her prior to noon that day?
It was about, I don't know, noon and I was helping out all day.
And it was a kind of complicated question. Had you spent any time with Miss McCray prior to noon that day?
I don't know. I'd have to check my phone and see when I started texting her.
No question on the floor, you can answer. On direct, you stated that you guys went to Meyer, is that right?
Correct.
Is Meyer the only place that you guys went during that day?
No, we went to her father's house so she could get her mail and other stuff. We also went to a place where she has to go for testing regarding her conviction for drugs at Grand River and something. It's on the phone.
So about how many hours on the date of June 1st, 2022, do you think you spent out running errands with Miss McCray?
9.
And at no point during those 9 hours was she out of your sight?
Not that I'm aware of. I don't know.
You don't know?
Not that I'm aware of.
And your last trip would have been to Meyer?
Correct.
And that's when you returned home?
With Claire, yes.
You've made several statements regarding this matter back on June 1st to the first responders in your 911 call. Would that be accurate?
Yes.
You ever recall telling any officer that you had forgotten toilet paper and ran back to the store to get toilet paper?
No, because I went to the bar.
So that's a statement that should not be attributed to you?
Yeah, I didn't go get toilet paper.
At any point in time, did you tell anyone that you only left her alone for about 5 to 10 minutes?
At no time did I ever say it was 5 to 10 minutes. It was approximately 45 minutes to an hour.
When you left to go to the bar, was the front door locked?
Mine?
Yes.
Well, I have an apartment house that has 3 apartments. So I was in my own apartment. I was letting you stay in a separate apartment altogether.
And that separate apartment is the basement apartment, correct?
Correct.
And it has a separate entrance, is that right?
Correct.
And the entrance to that basement apartment isn't off the street, but it's actually in the back of the house, right? So someone could have entered the house while you were gone?
If she would have told somebody to enter the house, then
Witness, listen to the question. Someone could have entered the house while you were gone?
her apartment, yes.
Be fair to say, with separate doors, someone could have entered the house while you were there too.
Yeah, she would have had to tell somebody where she was because nobody was supposed to know where she was at.
But you hadn't seen anyone enter or leave the house back on June 1st of 2022.
No.
And you can't say who, if anyone, came in during those early morning hours prior to your involvement with her at noon, correct?
Correct.
And you definitely can't say who, if anyone, came into the house on June 1st of 2022. During that time you were at the bar. Isn't that right?
Except for the person she was texting.
Isn't that right?
Except for the person she was texting.
So when you came back into the house, you didn't immediately go down to Claire's apartment, did you?
No, it's locked the door, mom.
And about how long were you on the phone with her mother?
Maybe 5-10 minutes.
So you're gone approximately an hour. You're on the phone approximately 10 minutes. Fair to say?
When I got home.
Now, when you came back when you went down to Claire's apartment, was the door locked?
No.
You knocked before you went in?
Yes, the door was closed.
You knocked?
Yes.
No answer?
No answer.
So you invited yourself in?
Or I could see in the window in the door.
So you invited yourself in?
Yes, because I saw Claire on the couch.
And she could have been sleeping?
No, she couldn't have been sleeping. You don't sleep with your face planted in a couch.
And when you went through that door, you found her in the basement, slumped over, planted in the couch?
Yes.
And it's your testimony today that she wasn't breathing?
Correct.
Drool coming from her mouth? Some liquid
Yes.
you described, right? Turning purple?
She was already purple.
I think you described her as shirtless, with her pants pulled down.
All the way to her feet. They were very tight pants, and women don't take their pants off with it.
I think you said it reflected the process of her being raped.
That's what it looked like.
But you don't know that for sure, do you?
I talked to the officer later. They said
You don't know that for sure, but the officer said you can't testify to.
all I can say is how she looked.
So that you then pulled her off the couch
Yes, I laid her down on the floor.
and you called 911?
Correct.
Did you move or touch anything at the scene?
No, they instructed me to give her CPR.
There was approximately 3 officers at your home that evening, right?
I only saw one.
You only saw one. Would that be Officer Magrum?
Excuse me?
Would that be Officer Magrum?
It was an officer, I don't know his name. I was a little traumatized, I didn't ask for his name.
A little intoxicated too from the bar, huh?
I said I was traumatized.
I heard what you said. Did you hear my question? You don't get to ask
Yeah, I
questions.
had a beer, I wasn't intoxicated. Don't imply.
So it was that officer that you were speaking to that you wanted him to understand that there was a baggie on the dresser, right?
I did not bring that up to him. I thought as an officer, he would have noticed himself.
You didn't bring that up?
No, I only noticed it missing when I came back down.
So at no time did you inform any Lansing Police Department officers at that scene of 529 West Howe?
Yes, I
that
did.
there was
after
drugs
I
on the
came
scene?
downstairs, and I said, hey, what happened to that baggie that was sitting on the counter right there?
So your testimony now is different than just
No,
a
it's
moment
not.
ago. And you described the packet as being on a dresser. Would that be accurate? And on direct, I think your statement was you're not familiar with heroin.
I'm not familiar with heroin.
So the packet that you described, would it be fair to say you described it as something in an envelope and a baggie?
Yeah.
Did you at any time open that envelope or open that baggie?
No.
So you wouldn't know if it was heroin?
No.
You wouldn't know if it was cocaine?
I don't know what it was.
You wouldn't know if it was weed?
For someone who died of an overdose. And
There's no question,
drugs
sir.
in it.
Question on the floor.
You have
Mr.
to
Green.
only answer the questions, okay?
And to your knowledge, the police never recovered it?
To my knowledge.
I think you stated on direct that it was missing after the EMT people.
Yes.
Told police on the scene that she had just been released from jail, is that right?
Excuse me?
Told the police she had just been released from jail, is that right?
About 5 days earlier. Around Memorial Day.
You were aware she had previously struggled with a heroin addiction, right? You were aware that she previously struggled with a heroin addiction, is that right?
Yes, because I kicked her out of the house before.
You didn't see anyone give her drugs that night, did you?
No.
You didn't see her ingest or inject anything, did you?
No.
Time you talked to the officer on the scene, you were clearly under stress, is that right?
When they got there, yes.
You're the one who found her.
Yes, I was very distraught.
You touched the scene before the police arrived.
Excuse me?
You touched the scene before the police arrived.
Is that a question?
Yes.
I'm sorry, Judge.
I was asking, was that a question?
And I'm gonna object to, did you touch the scene? I guess he's in the house or in the apartment. I don't know if he's, maybe we could clarify this, what part of the scene as opposed to standing there.
Well, at the very least, she moved her body.
Yes, I didn't know she was dead.
And you knew she had a drug problem.
Yeah.
But you didn't stop her from using. Went out to the bar.
I'm gonna object to
So
that.
there's an objection.
So that's being argued.
I'll strike it, Judge.
Stricken.
At the time.
Well, you don't have to answer that. They struck the question.
You prefer that the blame fall on someone other than yourself. Is that right?
I'm sorry, what's your question again?
You'd prefer that the blame fall on someone other than yourself. Is that right?
Somebody had to kill her.
Is that a yes?
There's no blame on me. All I did was find her and took action.
No further questions.
Redirect.
Thank you. You stated that when you came in and found Claire, there was a packet of some kind on the dresser. Initially, I believe your testimony was that it was a folded piece of paper and something plastic, and then you agreed during cross that it was an envelope. So can you describe the size of that for us, please?
Paper envelope thing that.
So you're
over like.
You're holding your fingers in maybe
1.5 by 1 inch, how about that?
1.5 by 1 inch piece of paper or envelope or something else?
Yeah, it was a folded, I didn't pick it up. I don't.
You didn't look inside the
No,
1 inch by 1.
it was sealed in a plastic like soda. Sealed it with like
Thank you. No further questions.
melted it or something. I don't know.
Okay, thank you. No further questions, Your Honor.
Oh, I did have a question. Sir, you made mention, I think at least twice that no one was supposed to know that where she was.
Correct.
How did you know that? Or why do you
She
think that?
said I had kicked her out of my house once before because of her problem about 6 months earlier.
Okay,
And she had just gotten out of jail. She said she had nowhere else to go, that nobody else would help her. She had just gotten robbed. She didn't have any of her belongings anymore. And, you know, would I please let her stay there? Would I please let her help her? She said she was clean. She had just gotten out of jail. She'd been in jail for 30 days. And so I said, well, you seem clean, you know, because I could tell the difference from when she was on heroin to how she seemed then. So I assumed that she had no connection with anybody of that trait. of
okay, so you
doing-
don't know if anyone knew where she was. You're just assuming because she just came from jail that to you that no one knew where she was?
Well, I told her she should, I didn't want anyone at the house of her because she had before tried bringing people to the house
Okay,
and I would send them away. I would make them,
okay, so you're not sure if anyone knew where she was then?
right.
Okay,
And I said the only way she could have is on her phone. She was texting somebody.
she could have told people where she was.
Right, exactly. So somebody would have had, it would have been on her phone when she was texting to go to the house.
They need cross or redirect based on my question.
Not for the people, Your Honor.
Did you pick her up from jail?
No,
Okay, thank you. You may be excused. There is a sequestration order, so you're not to discuss your testimony with any other witness, okay? There's a sequestration order, so that means you can't discuss your testimony with any other witnesses, okay?
all right.
Thank you. You can call your next witness. What did you call?
Amanda Hall.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? You can have a seat. Take a seat, counsel.
Thank you. Can you please state and spell your name for the record?
Amanda Hall, AMANDA HA.
And where do you work
Lansing Police Department.
and in what capacity?
I'm a crime analyst.
Can you describe for us briefly what a crime analyst is?
Crime analyst is in charge of doing data reports for the chief and the mayor. We also do investigative support help for the detectives.
Do you have occasion to do investigative support help for detectives? Reference a Claire McCray who was found deceased?
Yes,
And can you describe for us, please, what it is that you did with regard to the investigation?
I did a cell phone extraction on an iPhone SE.
You approach the witness, Your Honor.
Yes.
The sheriff's been marked as People's Proposed Exhibit Number 4 and ask you if you recognize what that is.
It is the flash drive where the report was saved.
And can you describe for us briefly how it is that the iPhone that you said that you downloaded now has ended up with some kind of thumb drive on the witness stand? What did you say you did?
So the process is when we receive the device, we connect it to a program called Breaky, which is essentially creates a bridge to talk to the device, and it will pull data from
said device, once the data is extracted, it is uploaded into Cellbrite Physical Analyzer, which creates a report for the investigator to review.
Do you yourself review the report, or you just give it to the investigator?
We do a few checks and balances to see that pertinent information did come off the phone and it was successful, but a full review of the phone is done by the investigator.
So your role in this was simply to take the phone, hook it up to the device, and come up with this thumb drive.
Yes, sir.
And does that thumb drive fair and accurately depict what was downloaded from the phone?
Yes.
People would seek admission of proposed exhibit number 4, Your Honor.
No objection to it. I'm just, Your Honor, I may approach. These are the other two that have been admitted. Now that they help me with them again.
I have no further questions, Your Honor. Thank you.
No questions of this witness.
Thank you. You may be excused.
Next witness is Megan Johnston.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
You can have a seat. State your first and last name and spell.
Megan Johnston.
Thank you. Just spell your name for the record, please.
Oh, I'm sorry. MEGANJOHNSTON.
Ms. Johnson, where are you employed
The Lansing Police Department,
and in what capacity?
crime analyst.
And can you describe for us, please, as a crime analyst, what you do for the Lansing Police Department?
We do a lot of things, which includes case support, data analysis, cell phone analysis, phone analysis, a bunch of different things to assist the detective.
As it pertains to a case involving the death of Claire McCray, did you have occasion to assist investigators with that matter?
I did.
And what was your role, or what did you do?
I was asked to map some call detail and phone records.
And what phone records did you use for that?
I was given T-Mobile records for Felipe Sotelo and AT&T records for Claire McCray, and locations from a phone extraction of Claire McCray.
Approach the witness, Your Honor.
Yes.
Did you eventually create some kind of mapping or report?
I did.
And I'm showing you people's proposed exhibit number 3. Can you tell us if you recognize what that is?
It is. It's what I provided to Detective McGonigal.
And what is it?
A PowerPoint presentation of various maps from the records that were provided to me.
And prior to coming to the courtroom this morning, did you have a chance to review that a little bit more detail?
I did.
And does that fairly and accurately depict what you made for Detective McGonigal?
It does.
And you stated that you used T-Mobile records from Felipe Sotelo and AT&T records for Claire McCray to compile that?
Correct.
And if I understand it correctly, those are cell towers that show times and what towers those phones were pinging off of, so to speak?
Yes.
I have no further questions, Your Honor.
Process, yeah.
Is it Officer Johnson or just Miss Johnson?
Miss.
If I understand your testimony correctly, you didn't generate the underlying carrier records yourself?
No, they were provided from the company.
So the phone data already existed prior to, you just prepared slides?
Correct.
And your work just simply plots timestamps and tower IDs visually?
Cell sites and sectors used, correct. And I believe there's 3 location points from phone extraction.
So no new data or testing is performed, right?
Correct.
And I think you just stated that the map was created by call detail records.
I used the call detail records, yes, to map the cell sites and sectors.
So the PowerPoint that you prepared, it's a map of cell tower locations.
Towers and sectors used, yes.
So not a map of Mr. Sotelo's, I guess, footsteps, for lack of a better term.
No, they were the sectors and towers used at the time it was interacting with the device.
What period of time does your maps cover?
I believe I was asked to map 8 PM to 11:30.
So would it be fair to say that your maps visual aids to show the direction that the tower faces?
Yes, based on the data contained in the records.
So they're not an estimation of the sector, right?
No, it is based on an azimuth, which is provided by the cell phone company. That azimuth is used as the center point in the sector that is mapped.
And it's not a radio frequency propagation map.
No.
And you know a radio frequency propagation map is a representation of how radio waves spread across a specific geographical area.
Yes.
And they characterize the wireless environment by predicting signal behavior, such as where signal will be strong, or will it be blocked by terrain, or where some sort of interference might occur. Is that right?
Generally speaking, your device is always looking for its best signal. So its best signal is going to be whatever tower and sector is reflected in that record. So at that time, that was the best signal that device had.
But my question was, the radio frequency propagation map would be, it would characterize the wireless environment by predicting signal behavior.
It would, but that's not the same as a call detail.
I understand,
Cell
but listen to
site.
my question, witness. You'll get your opportunity. Right, so an RFPM, for lack of a better term, it just will let you know where interference may occur.
It could.
Back to your cell tower sectors. They cover a large geographic area, right?
Depending, I mean, not that large when you're in a city.
And in your PowerPoint, you talk in terms of E-nodes. E-node B. Would that be a tower sector?
No, that's the tower number.
That's the tower number. And that sector for that particular tower can span miles, is that right?
Not in a city, no, not generally.
Did I ask you about a city, or did I
I'm
say?
gonna object to the argumentative nature of
I
this
agree.
question.
Objection sustained.
In general, cell tower sector can span miles, is that right?
There is no definitive length of time that we use because they truly vary based on the environment and the different things that are in those spaces.
So your shaded areas, you fair to say a cell phone can be outside of that shaded area and still connect with that tower and sector?
The shaded area is just a representation of that sector.
And your maps, your charts, they can't pinpoint a specific address, right?
No.
fact that you have 529 West Howe depicted in your map, that isn't to suggest that you pinpointed anything or anyone or any particular phone to that address, right?
No, it was an address based on the case report. It was not from the public records.
Two phones can hit the same tower without being close together?
Those are two different companies.
This is my question. Can two phones hit the same tower without being close together?
Generally speaking, no,
No, tell me why.
because they're always searching for their best cell site reception. So they will connect to whatever device is the best for that specific company.
So you'd also, can they hit two different towers if the phones are together?
Are they from the same phone company?
Yes,
Potentially.
but they're always searching for the closest tower.
No, for the best signal. Oftentimes that is the closest tower.
In your cell tower mapping, that's not the same as triangulation, right?
In this case, no.
It's just, your mapping is just based on identifying which specific tower the phone connected to based on historical call detail records, right?
Correct.
Triangulation is something different. A mathematical method used to pinpoint precise locations, right?
Yes.
So nothing in your slides places Mr. Sotelo at 529 West Howe, correct?
Not specifically.
All you're able to testify to today is the phone could have been anywhere within that coverage map.
That's correct.
But to accurately determine a phone's movements, you've got to analyze data over a period of time, right?
I don't understand your question.
You said that the period of time that you analyzed was between 8 p.m. and 11:30.
Correct.
And you were analyzing the phone's movements based on that discrete period of time, right?
Correct.
Okay. Would it be fair to say when you analyze too short of a period of time that you get a false idea of what movement means?
I would not think so, because I'm only looking at a specific period of time. I'm not looking for patterns. I am just looking for that specific time period.
You're familiar with the concept of tower handoffs?
Yes.
Towers get overcrowded, they hand off to another tower.
Yes.
So in order to know if it's handoffs going on or not, you need to analyze over a period of time. Is that right?
I'm unaware of that.
So you can't place Mr. Sotelo at the decedent's home based on your analysis, right? And you didn't plot the confirmed meeting between Ms. McCrae's phone and Mr. Sotelo's phone. Is that correct?
Correct.
So the tower times just match the timestamps that we already know from the CDRs.
I'm sorry, can you repeat that?
The tower times just match what we already know, the timestamps from the CDRs.
You mean the times reflected on that map?
Yes, ma'am.
That's correct.
The charts don't show the delivery of any substance.
They do not.
They don't identify what, if anything, was exchanged.
They do.
They don't even show if they actually met up, correct?
That's correct.
So your PowerPoint was just a visual aid, not independent proof of the meeting or delivery.
That is correct.
Just to help the court visualize the evidence,
Yes, that's correct.
but they don't add any new evidence.
It doesn't.
No factual information beyond carrier logs already available.
That is correct.
No further questions.
Redirect.
Thank you. Just so I understand it, and I would agree with Mr. Boyd, they don't show delivery of any kind and that type of thing. If I understand it, tell me if I'm wrong, they just show a phone that is connecting to a tower at different times.
That's correct.
And so based on the time, you can see where the phone's moving in relative terms to the tower or the area the tower covers.
Correct.
And if there was a throw over to another tower, is there a way you can tell that that's what happened? Because one tower was too busy, so it pushed it off to a different tower, or you wouldn't be able to tell that?
You wouldn't necessarily be able to tell that. Different company, at least from my knowledge and ability. Some of those things require something like an RF engineer who is employed, employed by the phone company who does that terrain mapping and who can actually give very specific locations for that tower coverage area. What I see and what is provided by the company in the case of T-Mobile is connection points for records, or for a record, it will link to a tower. With the AT&T records, it will give you a variety, or it could give you a variety of towers, especially with data usage. They do their records a little bit differently, but I do not as far as handoffs.
So, and as Mr. Boyd asked you, you took this from the data that was provided from the cell companies.
I did.
And it's not an exhaustive, almost like a fingerprint type situation. Would that be safe to say? What you make just assists in taking that raw data.
Beyond the scope of cross, Judge.
I think it's exactly within the scope when he was asking about what this represents, and I'm just clarifying.
Objections overruled.
You take that data and just put it into a map that we can visualize.
I did.
What's going on as best as possible.
Correct.
Just the first time that you've done this?
No.
How many times do you think you've done this for cases?
Oh, goodness. Probably at least a dozen.
And
well, I'm sorry. I've testified probably at least a dozen. I've matched all detail records for a number of years.
More than 100? Less than 100?
Probably, but I've been doing it for a number of years.
Thank you. Okay, Your Honor, I have no further questions. Thank you. Yes. Yes.
Thank you. May be excused.
Thank you. Next witness is Detective Martha McGonigal.
Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I will.
Have a seat. Let's state your first and last name and spell both.
Martha McGonigal, MarthaMcGonigal.
You can proceed.
Thank you, Your Honor. Were you employed?
Lansing Police Department.
In what capacity?
I'm a detective.
And is there a specific type of crime that you detect?
I am assigned to the violent crime team within the police department's detective bureau.
Thank you. And were you still employed on June 1st of 2022?
Yes, I was.
Did you have occasion to investigate the death of Claire McRae?
I did.
Do you recall were you assigned to that on June 1st of 2022 or some other time?
It came some days after the fact that I was actually aware of the case.
So then it's safe to say you didn't visit the scene when the body was discovered on June 1st of 2022?
That's right.
What steps or what things did you do to investigate the case?
So like I said, it was a couple of days thereafter the event actually occurred that I was made aware the case was going to be mine. I made some phone calls to Claire's family, to Mr. Redding, and the pathologist at Sparrow Hospital who performed the autopsy of Claire. And then I
The phone was taken into evidence at the time of the call. I then gave the phone
Let
to,
me stop you right there. What phone?
the phone that was recovered from Claire on the scene
Thank you.
was
Go ahead.
then given to the analyst Amanda Hall to perform a forensic exam of that phone.
Did you do any search warrants reference records for the case?
I did.
Do you recall what search warrants you did?
I wrote a search warrant for Facebook for phone records associated to the phone number that was within Claire McCrae's cell phone, as well as the phone number through T-Mobile that was associated to the person communicating with Claire at the time from the record of her physical phone extraction.
Prior to June 1st of 2022, did you know a person by the name of Felipe Sotelo?
Before that date, I did not.
Some point in time, did you develop a suspect with regard to the death of Claire McRae?
Yes.
Can you describe for us how it was or how it is that you figured that out, please?
So looking through the forensic extraction of the cell phone that was performed by Analyst Hall, I was able to see the last person that Claire was speaking with through her cell phone. And the physical messages were still contained within that phone.
So I'm going to show you what's been marked as People's Proposed Exhibit number 4A, and I'm going to let everyone in the courtroom know. I have 2B, C, and D. There'll be no 2A. It is now 4A because this comes from the already admitted 4. May I approach the witness, Your Honor?
Yes.
Can you look at that, please, and tell us what it is we're looking at?
This is an excerpt from the physical phone extraction of Claire McCrae's cell phone identified by the email address of claireseymour424@gmail.com.
And is that something that you found on People's Exhibit number 4?
Yes, it is.
And
That's a multi-thousand page file. This is just a few pages of relevance within that entirety.
so you looked on People's 4 for the day in question,
I did,
and that's what you found?
correct.
And does it fairly and accurately depict what you found on People's 4?
Yes, it does.
People would seek admission of proposed exhibit 4A. Can you, how many different colors are there assigned to the conversation, so to speak?
The content of the conversation is in 2 colors, green and blue.
Do you know who's talking in the green portion?
It's identified as being a particular phone number, again, with that same email address at Gmail, and the first message that is relevant is, hey, it's Claire, as the context. That message is identified also as not just the email address, but also from a phone number and to a particular phone number at 8:19 p.m.
And the associated phone number in that first text, did you, based on the course of your investigation, have the ability to figure out which phone number that was?
I did.
And who was that?
Felipe Sotelo.
So is it safe to say then that Felipe Sotelo is the person talking in the green or the blue?
The blue conversation in Exhibit 4A is that.
And who is the green?
The green is Claire.
And what is the first text message? I'm just going to ask you to read it. So if you could go through it, what's the first text message?
The first message here says, hey, it's Claire, and the timestamp on that message again is 8:19 p.m. on June 1st.
And what does the next message say?
The next message says, you got any question mark? The time on that is also 8:19 p.m. on the 1st of June.
Is that also from Claire?
Yes, it is. It's approximately 3 seconds after the first.
And then the next message?
The next message is in blue. It's depicted as between the phone number of 517-763-9906. And that phone responds, yeah, how much?
And what color is that?
That's blue,
And so that's affiliated to whom?
Mr. Sotelo.
Okay, and then, go ahead.
The timestamp on that text message is the same date at 8:20 p.m.
How long after the first message asking, hey, you got any, is that roughly?
Approximately 20 seconds.
And the next message?
The next message is in green, signifying being Claire. It says, I'm around people who can't know I'm getting any. That's at 8:20 p.m.
And then the next message,
The next message is a few seconds later, still at 8:20 PM. And Claire states, I got 50.
and what's the next message?
The next message, approximately 29 seconds later, is depicted here in blue from the same phone number that says, okay, WYA, which means where you at?
And that's again from what you, based on your investigating, learned to be Philippe Sotelo's phone.
It is, and that message comes approximately 11 seconds after Claire's.
And then the next message,
The next message is Claire saying Northwest Howe Street. The timestamp on that message is 8:21 on June 1st.
and the next message,
The next message is, can you come to Village Off K Zoo? The timestamp on that is 8:24. And that message is in blue signifying it's from the phone number of Mr. Sotelo.
and the next message,
The next message is, I mean, I can try. I got my car impounded and my driver's license taken. That message was sent by Claire at 8:24, same day.
next message,
The next message is in blue signifying Mr. Sotelo. Says, go outside and call me at 8:27. So approximately 3 minutes past.
and then the next message,
Next message is also from Mr. Sotelo. It says, send me the address. I'm on my way, RN. That message is at 8:27.
do you have any belief of what RN could mean?
Right now is what typically.
And the next message,
The next message is Claire stating it's 523 West Howe Street at 8:28 PM.
and then the next message,
The next message is in blue signifying Mr. Sotelo. It says that's an hour away. That message is also at 8:29. A few seconds. Oh, I'm sorry, I misspoke. It's at 8:29, so approximately a minute later.
and the next message,
The next message is Claire stating 529 West House Street, don't pull in the driveway. Also at 8:29, approximately 15 seconds after.
and the next message,
The next message, excuse me, the next message is in blue. It says 10 minutes away. I'm sorry, I misspoke. 10 mins, my bad, be red.
and that's in blue, meaning it's who?
Mr. Sotelo, and the timestamp on that is a few seconds after, also at 8:29 PM.
And the next message,
The excuse me. The next message states ready, also in blue, still at 8:29, 2 seconds after the first.
and the next message,
Is in green. It says, okay, I'm on my way back from the Lake Lansing Mire, so I'm not even 10 minutes away. And the timestamp on that is 8:34.
are there any more text messages in that exhibit?
There are not more messages in this exhibit.
Thank you. Just grab that back from you. May I approach, Your Honor?
Yes. Thank you.
Understanding that there's now no exhibit 2A, I'm going to show you what's been marked as people's 2B. So, Mr. Boyd, may I approach the witness?
Yes.
Ask you if you can recognize what that first page is for us, please.
So the first page is a certificate of authenticity from the Meta platforms, formerly known as the Facebook.
And the entire file or I'm going to ask you to look at the next page. What is that?
This is again an excerpt from the very large file that contains the entire Facebook search warrant and return.
And is that on what we've marked as people's and entered as people's exhibit number 2?
Yes, it is.
And you went through that exhibit number 2?
I did.
And you looked for relevant material
I
based
did.
on this investigation?
Yes, I did.
And what is it? You stated that exhibit 2B is a Facebook document?
It is.
Does it fairly and accurately depict what you found?
It is.
Whose Facebook account is it from?
Claire McRae and the username of Lot of Tape.
And you already said fairly and accurate. So people move for admission of proposed exhibit 2B?
Be like boy, correct?
That is correct. No objections.
Admitted.
And what in relevant part does that state?
So this is again a conversation between the user ID of Lot of Tape and Claire McRae. The way that Facebook works, the Facebook identity number is the number that is associated to account. The username can be changed regularly, but the person with that account, that number stays singularly with them. So a lot of pay could be by a different name tomorrow, but that number associated through Facebook is the account number.
And a lot of paid account number, give us what's the last four.
The last four is 7801.
Based upon your search warrant return and what's been admitted as an exhibit, did you get information as to whose Facebook page that is?
I did.
And who is that?
It returned to Phillips Salido. I'm sorry, Sotelo.
Is there any other Facebook account referenced in that People's 2B that is relevant to this investigation?
Yes, there's also Claire McCrae's conversation with other people, which leads me to believe that this particular excerpt is from Claire's account, not Mr. Sotelo's account.
And does Claire's account have a last four-digit number that is associated with it?
It does, it's 7439.
And what, if any, is there any communication between Claire and Philippe Sotelo in 2B?
Yes, there is.
And what is that?
So from the return on Facebook, there's a date provided to Facebook as the content that I am requesting. So I can tell by the information returned that their conversation began on December 8th of 2022.
And what is that conversation consist of?
It doesn't tell me any of that. It just tells me that as of the date the search warrant was written, that conversation still shows in their record.
Is there anything in 2B that shows anything of relevance as it pertains to June 1 of 22?
Yes, there is.
And what is that?
So the Facebook record comes back in UTC time, which is converted at this time of the year in Michigan to be 4 hours prior to the date listed on the UTC.
When you say this time, you mean this time on June 1st of 22 or
Correct.
today?
On June 1st of 22, the difference between UTC and Eastern time is 4 hours. So at 23:51 as the first message, it's really 8:51.
And what is that message?
That number is Claire saying, yo, what's your, and then it's a percent sign.
Is there anything else relevant in that document?
Yes, a few seconds thereafter, actually 1 second later, it's a number sign. Also written by Claire to the user ID associated with a lot of fake 7801.
And so that was Claire asking for a number.
Correct.
Can you tell who that was going to?
The lot of fake user ID ending in 7801 has been associated with Mr. Sotelo.
Is there anything else in that exhibit that is relevant to the June 22nd? I'm sorry, June 21, 22 date?
Yes, I can see that there's been a message sent by the account Lot of Faith. Actually, there are two messages sent by Lot of Faith, and both show that Lotta unsent those messages. So once the message is unsent by either the sender or the receiver, it's no longer something that Facebook keeps as data record.
So there,
Whatever that message said, it only shows me that that message has been deleted. There's no data that gives me the actual content of those two messages.
thank you. Let me just ask you this, during the course of your investigation, did you, you stated you identified Philippe Sotelo, is that correct?
I did.
Do you see him in the courtroom today?
I do.
Can you describe an article of clothing and where he's seated?
Sure, he's seated to my left wearing a light blue shirt and a white tie.
Will the record reflect the witnesses identified the defendant?
Any objection to identification?
No.
Identification is noted.
Thank you. Anything else of value to your investigation found in People's 2B?
Not in 2B.
Thank you. I'm going to show you what's been marked as People's Proposed Exhibit 2C. And ask you if you can tell us what the first page of that document is. At first, please. May I approach your honor?
Yes. Thank you.
This is a certificate from T-Mobile stating that the employee at T-Mobile certifies the records as being a true and accurate depiction of the records that their company holds.
In the regular conducted course of business?
Yes,
Is that
that's correct.
And if you flip the page, can you tell us what it is we're looking at there?
This is the subscriber information for the phone number associated with 517-763-9906 from the date range of May 15th, 2022 through 6/15 of 2022.
And that kit also came from the entire file that you received, that's People's Exhibit 2?
Yes.
And does that indicate to you what that phone number, who that phone number registers to or belongs to?
It does. It gives me the name of Philippe Vitello along with an address.
And what's the address?
1224 Vermont Avenue, Lansing, 48906.
Is there anything of evidentiary or investigative relevance as it pertains to People's 2C?
I can see through this information that that phone number is still active on the date of September 27th of 2022. And it became active on January 19th of 2022. So for those approximately 8 months, 9 months in that time frame, it was an active phone number with T-Mobile as the service provider.
And forgive me, I can't recall now if I moved to admit 2C. If not, I would seek admission of 2C.
Okay, objection.
No.
Admitted.
Thank you. Anything else of investigative or evidentiary value in 2C?
Not in this particular exhibit.
I'll show you some marked as People's 2D. Approach the witness, Your Honor.
Yes.
Tell us what the first page of that is, please.
And give the certification from Mega, previously known as.
You said Meta?
Yes, Your Honor.
And is that also called from a file that's in People's 2?
It is. So
Yeah.
this is the account number ending in, I'm sorry, the account ID ending in 7801 associated to username of Lava Pay.
And that's a Facebook record?
Yes, it
Does
Mm-hmm.
is.
it fairly and accurately depict what you found on People's 2?
It does.
People would seek admission of proposed exhibit 2D.
No objection.
No objection, Judge.
To be submitted.
And can you tell us from looking at that document, the last four of the account holder 7801, who that belongs to?
Mr. Sotelo.
And is there anything, any texts or conversations contained in People's 2D?
There's not conversation, but there is data relevant.
And did you look for conversations in
I
2D?
did.
And was there any, you said there were none there.
Correct.
Is there an indication as to why there are no messages contained in 2D?
I can see that Claire McRae with the user ID number of 7439 was deleted from this account on June 2nd at the UTC time of 10:26 p.m.
So there were no conversations, so to speak. Is that based on the fact that the account was deleted or the
Correct.
conversation was deleted?
Well, based on the fact that the friend is deleted from that account, so no conversations with that person are still listed in their Facebook meta return.
And you stated that was on June 2nd of 2022 that it was deleted.
Yes, it was.
Anything else of investigative value in 2D?
Nothing.
Thank you. May I approach, Your Honor?
Yes.
Show you what's already been admitted as People's Exhibit 3. Did you use People's 3 to assist you in your investigation?
I did.
And what is it about, or let's go to the second page of Exhibit 3. What is that to your knowledge?
This is the cell phone mapping as it pertains to the records coming from T-Mobile, as far as where the phone and the towers associated with that phone hit during the time frame.
Let me ask you this. When we do these cell phone mappings, it tells us where the phone is pinging off a tower. Is that safe to say?
Yes.
Doesn't necessarily mean that's where a person is pinging off a tower. Is that correct?
That's accurate.
Thank you. Nonetheless, is there anything that you used in your investigation in People's 3 that assisted in the investigation?
There is.
And what is that?
The timeframes show that the phone was in the vicinity of West Howe Avenue, 529 West Howe to be specific, at the time of 8:41 p.m. And then it's on a different space within the city of Lansing still in the time frame both immediately following.
And which phone is that?
It's the phone number associated with Philippe Sotelo, 517-763-9906.
So, and as Mr. Boyd pointed out with Ms. Johnson, it doesn't show the phone at 549, correct?
That is correct.
It just shows it on a tower covered in that area. Is that safe to say?
Yes.
Anything else about that second page that assists us in the investigation?
It's the same area that the village off of Kalamazoo would be and the additional things after that time frame.
And that was one of the locations, one of the previous exhibits we looked at that Philippe Sotelo had asked Claire to go to. Is that not correct?
That is correct.
Anything else on that second page?
Nothing.
I'm gonna ask you to flip the page to the third page and tell us if there's anything on that page that assisted you in the investigation.
There is.
What is that?
So this is the mapping of Claire McRae's CDR data through AT&T and her time frame was from 8 p.m. through, I believe, 2300 or 2330. And the phone is in the area that she mentions being at the Lake Lansing Mire to begin with, and then during the next period of time, her phone shows within the same area of 529 West Howe Avenue.
Anything else on that third page that assists us?
Her phone doesn't move from being in the vicinity of the tower of 529 West Howe after 2308.
And you, I believe you said that it goes up to 2330.
Correct. So the last data that was used to obtain this map was used at 2308.
And if I'm not mistaken, 23 is 11 p.m.
That is correct.
Thank you. Anything else on the third page to assist in the investigation?
No.
I'd ask you to flip the page to the fourth page and same question, anything there that you used to assist in the investigation?
Yes.
And what is that?
So this is the GPS data that was located on Claire's physical phone extraction. And that only lists 2 location points. So the phone, for whatever reason, grabbed the 2 location points based on usage. And the locations are, the location number 2 is the Mire. Location number 1 is the intersection at Wood and Lake Lansing Road, just outside of the city of Lansing and Lansing Township area. Those both occur between 8:22 and 8:27.
To your knowledge, that Lake Lansing and Wood intersection or area close to the Lake Lansing Mire?
It is. It's less than a mile from there, between there and Howe.
Anything else on that page?
No.
I'm going to ask that you flip and go to the next page. I believe that's the fourth page. And is there anything on that page that assisted in your investigation?
So this is also the AT&T CDR locations based on those records for Claire McRae's cell phone number provided by AT&T. That number is 517-488-3750.
And does that show any movement or location?
It does. It shows the movement again from where Lake Lansing Road Mire is through the area near Eastwood Town Center. And then the tower near Business 27 at the railroad track, so near Turner Street. And then it's not the last, but another plot at 529 West Howe is included within that data as well, with the timestamp of 8 p.m. and 22 seconds.
Thank you. Push the just for a moment.
There's one more.
Okay. Based on that page you were just describing, anything else that assisted in the investigation?
Yes, so the last page is the data from Felipe Sotelo's phone, the physical phone extraction data from Claire McRae's physical phone, as well as the records from AT&T plotted on one map.
So let me stop you. So everything we've talked about, that just puts it all into one map, so to speak.
Yes.
And so that shows all the movement and all the towers from everything that we described on the previous pages.
It does.
And so for expediency, I'm not going to ask you to go through all that, but that's what that's showing is just a totality of all that information.
Yes, it's all of the records from 8 p.m. to 11 p.m.
Thank you. Unfortunately.
Yes.
Pursuant to your investigation into the death of Claire McCray, did you do anything else other than the records and the search warrants that you've described?
I did.
And what is that?
I spoke with the medical examiner, forensic pathologist after talking to Mr. Redding. And I spoke, like I said, at length with her family and Mr. Redding at this point, and followed up on some of the concerns of both of those people as far as who may have been with Claire in Mr. Redding's absence.
Were you able to determine that there was anyone else from an evidentiary standpoint who was with Claire after Mr. Redding left the residence and went to the bar?
From physical evidence, the only thing I have is the phone records. There was nothing otherwise.
No other evidence of anyone else? Not saying that there wasn't anyone else, but there was no other evidence of anyone else.
That's correct.
Is that safe to say?
Yes.
Thank you. I have no further questions.
It's off the record. Take a break for 5 minutes.
All rise.
Back on the record. Cross-examination. Cross-examination.
Yes, ma'am. Forgive me if I butcher your name. Mechanical,
McGonigal with a G.
McGonigal. Thank you. Detective, would you be considered the officer in charge of this investigation?
I was.
And as the officer in charge, it's the supervisory role, you marshal the evidence.
I'm assigned the case after the fact, so what happens on scene is not something that's my responsibility in this particular matter. So to say that I marshal the evidence, I do after the fact, but not during. That makes sense as an answer.
It does. And do you know when you first became involved? You said days after, but did you happen to know the exact date?
I don't know the exact date.
And so when you're assigned after the fact, you spend your time going through police reports, getting up to speed on the case, right?
Yes,
Talking to other officers.
maybe not other officers, but witnesses.
And you described on direct reviewing messages, and you even read some into the record. And those messages you reviewed, they were from both the decedent's phone, correct?
Some of them were from the decedent's phone.
And those messages from her phone was from her native Gmail account?
As well as a phone number that was associated to it.
And so the phone number, in your investigation, you identified two phone numbers that were associated with this phrase, is that right?
With the cell phone device itself, yes.
And would it be fair to state that one was 517-748-3750?
3750 is the last four, and I don't recall without seeing the phone numbers again exactly.
Is there anything that would refresh your recollection?
Sure, a copy of the information.
Yeah, approach judge.
Yes.
So your recollection been adequately refreshed?
Yes, the numbers end in 3750 and 8350.
Said the numbers end in 3750?
No, I did not.
Did you say the numbers end in?
8350 and 75. No, that's not right. 50 is the last. 7350. For me, I see it again.
Can I approach again, Judge?
Absolutely.
And what were those numbers, ma'am?
8350 7350. I'm on the struggle bus. May I write them on a piece of paper? Your
I
Honor?
have no objection, Judge, as long as it's okay with.
How about you just ask her the number that's crossed, you can ask
I got
a
it.
leading question and
Thank you.
So if I were to tell you that in your report, page 1 of 2, dated March 18th of 2025, that you indicated that the phone numbers associated to Ms. McRae are 517-748-8350 and 517-488-3750. You have no reason to object, correct?
Those are the phone numbers that were associated to her physical cell phone, correct?
And as the officer in charge, you're the final authority on the accuracy of search warrants, search warrant affidavits, things of that nature, correct?
I did write search warrant and affidavits, if that's your question.
And you understand that even a single digit error in a phone number can point to the wrong person.
Correct?
And you'd agree that identifying the correct phone numbers for the decedent is one of the most critical steps in a delivery cause and death investigation.
I would agree that it is critical. I don't know that I give it that much of a emphasis.
Okay, and that's because you want to establish who was and who wasn't communicating with one another, right?
Yes.
And I believe on direct, you testified that you had the opportunity to write search warrants and search warrant affidavits for Mr. Craig's phone.
I did.
And do you remember the numbers that you listed in the search warrant affidavit and the search warrant?
Not off the top of my head, I don't.
Is there anything that would refresh your recollection?
You're asking me specific questions about the search warrant would help.
Approach, Judge.
Yes.
Take a minute to review those documents. And an opportunity to refresh that recollection.
Yeah.
can we just describe for the record what it was that was used to refresh the recollection, please?
For the record, Judge, the affidavit for the search warrant for the place or thing to be searched is the AT&T Mobility Singular belonging to Claire McRae, and the search warrant affidavit and the search warrant. And then that search warrant and search warrant affidavit, we listed the numbers as 517-488-3750.
That's correct.
And 517-748-3750.
Correct.
You see your error?
I do see my error.
That's 3750 versus 8350,
That's
correct?
correct.
And so when you got a return for the search warrant, nothing came back, is that right?
That's not correct. The data records for the correct phone number came back associated with Claire McRae. The phone number that's incorrect on the search warrant came back to a completely different person.
And that would be an Aaron Hornback.
Yes,
So the second actual number for Ms. McCray was never included in the search warrant.
that's correct. The error that came to light after the fact long enough that I was unable
No
to
question,
correct it.
no question. before. So because the correct number was never on the warrant, AT&T was never legally compelled to turn over any information, is that right?
No, that's not right. AT&T turned over data for the correct phone number as well as the incorrect phone number. The correct phone number was given as Claire McRae's phone.
So the phone number that you inverted numbers and did a Scrivener's error, you never got any information back from AT&T on the number that was identified as being associated with Miss McCray, is that right?
The second number, that is correct.
And as the officer in charge, you were aware of evidence that had been obtained from Miss McCray's actual device, is that right?
Yes,
And you're aware of a text message sent asking if Miss McCray still wanted dog, correct?
yes,
And you know, dog is common street slang for heroin, is that right?
yes,
That text message didn't come from Mr. Sotelo's phone, did it?
it did not.
Perhaps it came from a third party,
I have no idea who it came from.
didn't come from him,
Didn't come from that phone number.
someone you didn't focus on in your investigation.
Correct?
So you focus your resources on my client based on an incomplete and inaccurate set of phone records.
That's not true.
No, but you didn't have the correct number that you identified in your search warrant.
That wasn't the only basis for the investigation.
So it'd be fair to say, though, the magistrate signed the warrant, it didn't match your investigative notes as to the phone number.
Correct. There was a typographical error listed on the phone number. One of the two phone numbers.
So would you agree that searching the wrong phone number, you close your eyes to other potential sources of that heroin?
No, I would say that I had an accidental typographical error on the search warrant that wasn't noticed until after the fact.
You also understand that accurate timelines are critical in the death investigation. Is that right?
Yes,
You relied on Mr. Redding's timeline to do your investigation. Right?
that's not completely accurate.
But you adopted a timeline associated with Mr. Redding in your affidavit for your search warrant.
In part, Mr. Redding. Also in part, the cell phone data that I was able to retrieve from Claire's physical phone.
And Mr. Redding's account was that he had been gone at least an hour. Isn't that right?
In which time frame are you referring to with your question, please?
I'm sorry, let me back up. Back on the date of June 1st of 2022, Mr. Redding had indicated to you that he was gone for about an hour. Isn't that right?
I didn't speak to Mr. Redding on the day that this happened.
I didn't say that you spoke to him on the day. My question was that Mr. Redding told you that back on June 1st, at the time of this incident, that he had only left Miss McCray for about an hour. Is that right?
Yes,
Is that what you put in your search warrant affidavit?
again, I don't recall exactly what's written in the search warrant affidavit without looking at it specifically.
Perhaps taking a look at your search warrant affidavit, will refresh your recollection, ma'am.
Yes.
Now, approach judge.
Yes. This is a different warrant than the one you previously showed me. This is to T-Mobile, not to
I'm going
AT&T.
to establish with the court what the record is that we're relying. Does it adequately refresh your recollection, though?
Yes, it does.
Would it be fair to say that you characterize Mr. Redding's statement as he had been with McCray until about 10 minutes before he located her deceased?
That is the information that was in the police report that was reviewed at that time, not from
Yes
Mr.
or
Redding
no, ma'am?
directly to me. If you look at the first line of that search warrant, it says from reviewing and investigation and conversations with Mr. Redding. It's not strictly from my conversation with
About
Mr.
5 or 10
Redding.
minutes is what your affidavit says, correct?
That was the accurate information at that time.
So at that time, you presented a 5 to 10 minute window as a fact for the magistrate to sign the warrant.
That's the best information I have when that warrant was prepared.
And at that time, you swore that there was no other statements made by Terry Redding that contradicted that 5 to 10 minute window.
That is not written in that search warrant.
By taking an oath, that's what you're doing, right?
I'm swearing that that information is true and accurate to the best of my belief, which it was at the time.
So, have you reviewed any of the evidence in the case that you were the officer in charge of at the time?
Yes, I have. Thank you.
So if we were to look at the 911 calls, the precipitous of this event, he said he had been going for an hour.
That's not what the officer's police report wrote, who wrote the initial police report. That's the information that was used when that particular search warrant was read.
You'd agree 1 hour is significantly longer than 5 to 10 minutes that you swore to the warrant, right?
Yes.
On the rec, you testified as to a series of text message exchanges. He says the last message says pulling up. There's no surveillance to show any person riding, right?
That's correct.
Those messages were exchanged at about 8:50 that night.
Yes.
You have any evidence, text, photos, videos, or eyewitnesses showing that Mr. Sotelo actually arrived?
No.
You have any videos showing the defendant in her home?
No.
Timeline for access to that house went from 5 to 10 minutes to about an hour. You agree with that?
Yes.
And whether it's 5 or 10 minutes or an hour, no one saw Mr. Sotelo come in or go out of that house, right?
I did not locate anyone that saw him.
You know what time 911 was called?
Not the exact time.
Medical examiner's report, tox report shows heroin and fentanyl in her system, right?
Can I see that? I have seen it, but I don't know the other things that are also listed as being in the system of Ms. Claire.
It's an admitted exhibit. We can just show it. You can just read from it at this point. Thank you, Judge.
Direct your attention to page 104.
You're talking about not the tox screen, but the actual autopsy report?
The actual autopsy.
Yeah.
Says died as a result of toxic effects of fentanyl.
Yes.
Well, let's jump down to page 1 of 7, of the tox report. Says Ms. McCray tested positive for cannabinoids,
Yes.
tested positive for, again, opioid, fentanyl. Reference range is associated with comatose and fatal case reports attributed to abuse of fentanyl.
As well as other things, yes.
Way back on page 4 of 7. It says that she tested positive for stimulants, benzoyl lycamine, metabolite for cocaine, correct?
Yes.
Also a prescription drug depending.
No question on the floor. Are you able to confirm the product allegedly referenced in those text messages is the same drug that you alleged that Mr. Sotelo distributed?
No one saw what was in the package.
Package you just referred to is the package that Mr. Redding described as being an envelope being closed in some plastic.
Was that not your question?
Package you just described was an envelope contained in plastic that Mr. Redding described on his direct and his cross-examination, correct?
Perhaps I misunderstood your
I
question.
think you're still misunderstanding my question because you're not asking the question that's been presented to you.
That's what I'm asking.
Let me
you to
repeat it for
sir.
you one more time.
Thank you.
The package that you just described in response to my initial question was the package that Mr. Redding had talked about on direct and cross-examination, right?
That is what I thought your question was. I don't understand
So
what
that's
your
a
first
yes.
question
That would be a
was.
yes. You were talking about that package?
I don't,
I can move on.
I don't, okay, 'cause we're talking over each other and I don't understand what's going on, to be
He's
honest.
gonna move on, thank you.
Sorry. That's-
Be fair to say that the package that Mr. Redding described was never recovered,
That's correct.
and you don't know if there was cannabis in that package?
You just said it wasn't.
You
located.
don't know there wasn't cannabis in that package, right?
It was never found.
And you don't know if there was cocaine in that package.
Again, it was not found. I have no idea what was in a package that we never found.
And you don't know if there was heroin in that package, correct?
Still, same answer.
And that's the package that you're attributing to Mr. Sotelo, right?
That's not what I'm saying.
Tox report didn't indicate any unique binder or filler or anything that you can identify
No.
to Mr. Sotelo?
It did not.
Nothing was ever recovered, so there's no stamps or particular packaging or anything that may be able to be attributed to some suspect.
No.
But you can't confirm any substance linked to Mr. Sotelo, can you?
No.
And you don't know if she obtained drugs from anyone else while Redding was out of the house?
I don't know that.
You'd agree that your investigation found 3 distinct substances found in her system?
There's multiple substances. Some of them are metabolites of another.
Including benzoyl lycamine.
Correct.
Find any evidence that my client was the source of the cannabinoids?
I did not.
About the cocaine?
I did not.
About the fentanyl?
No,
No, when Ms. McCray actually used the substance to cause their death?
based on my training and experience, it had to have been in close succession of time.
Is it possible that she had the drugs earlier in the day?
Certainly.
You can't rule out someone else delivered or gave her those drugs earlier, can you?
I can't.
Does the report account for the synergistic effects of adding a powerful stimulant like cocaine to fentanyl?
I'm sorry, did you report?
Toxicology report, I'm sorry.
I'm unable to speak on the medical aspect of this.
Since you aren't a toxicologist, you can't say if the decedent would still be alive had she not also used cocaine.
Correct.
And you can't rule out that the cocaine was the primary factor that caused their heart to stop.
I can't.
Those text messages that you talked about at 8:19 p.m. beginning with Claire sending a message to which you attribute is Mr. Sotelo's phone. It's pretty vague. You got any? She never defined a substance, did she?
She did not.
No further questions, Judge.
Thank you, Your Honor. Detective, you asked some questions about a search warrant or two and a incorrect phone number. Did you, after you obtained the wrong records, try to fix that and resubmit the search warrant?
I did. The time frame had passed. They no longer retained the records at the time the error was noticed.
And just so that we're clear, the records that have been introduced as the text messages, I believe that was People's 2B. I'm sorry, that was People's 4A. That came from your search warrant returns or directly from Claire's phone?
It came from the phone itself.
So the incorrect phone number issue has nothing to do with that record. Is that safe to say?
That's accurate.
What was the purpose, and if you had the phone and did an extraction of the phone directly, to go and get records from AT&T as well?
So whatever is deleted from the physical phone wouldn't have been available on the physical phone. Sometimes phones have multiple numbers associated to them based on if I bought a cell phone from you and I didn't clear all of the data, it would have both of our phone numbers saved on it. In a situation like that, the accurate information comes from the phone company directly.
That doesn't make what was on her physical phone any less accurate, would it?
No, it doesn't.
There was some questions reference GOG and that being heroin that you were asked about. Do you recall when that conversation occurred in relation to June 1st of 2022?
There were some on June 1st before this time frame. And then the responses back to the texter stopped obviously upon Mrs. McRae's passing.
Were there any texts involved in that conversation that showed that someone was coming to give Ms. McRae anything?
Only one.
And is that the one you've already discussed here in court?
It is.
You were asked about the admitted exhibit and the texts not describing what it was that Claire was asking for directly, as far as give me heroin, give me fentanyl, give me cocaine, give me marijuana. Is there anything in the text that gave you rise to understand what she was asking for?
The dollar amount mentioned.
That being what?
50.
What is it about 50 that makes you think that assisted in the investigation?
Someone buying $50 of marijuana wouldn't be enough to hurt themselves to the point of overdosing on them.
Are you still in possession of the autopsy report?
I am.
And I can cover this in a minute, but just on the first page, of the actual report under final diagnosis, can you just read what it says under number 1?
I can. It says number 1, toxic effect of fentanyl. A, history of drug use. B, toxicology positive for fentanyl/metabolite.
Thank you. I have no further questions, Your Honor. Witness is excused on mine. Yes, thank you.
Any other witnesses?
I am not, Your Honor.
Will the defense be calling witnesses today?
No, Judge.
I'm not sure. What was this?
That goes with the autopsy report. Your
Oh,
Honor. That's the
okay.
toxicology
Got
report.
it.
Somewhere along the way, I misplaced the paper.
No worries. I just wanted to make sure I attached it to the right thing. Proceed to argument.
Thank you, Your Honor. People seek bind over as it pertains to count 1, delivery of a controlled substance causing death. The evidence that the court has heard today, first from Mr. Redding, is that he lived in a house where the decedent Claire McCray was staying, that he had let her stay there, that he was kind of keeping an eye on her and did leave for a period of time and went to a bar. Upon returning, he found her dead and in a manner of undress, but nonetheless that she was deceased, that there was a small, he described it as a 1 inch by 1.5 inch piece of paper in plastic located on a dresser in the same room that she was in, and that he tried to revive her. He could not. He called 911. Excuse me. We're testimony from some analysts at the Lansing Police Department, Amanda Hall, who did a phone, for lack of a better term, a phone dump of her physical phone that resulted in the text messages that we see in people's admitted 4A, which shows a conversation and I won't go through the basis of it, but the records are in evidence that show who was talking, and that being Claire McCray and the defendant Philippe Soleto, discussing in the relevant time frame the acquisition of 50 of something, that they discussed that you can't float the driveway, Where should we meet? Those types of things that are evidenced in 4A for the court and the conversation they had back and forth. Reference the ordering of what the people submit was a controlled substance that caused your death. The court's in receipt of an autopsy report that indicates that Claire died from the toxic effects of fentanyl with a history of drug use and toxicology positive for fentanyl/metabolite. Does not indicate anything about the exacerbation in that part of the report from use of cocaine or cannabinoids, THC, marijuana. According to the autopsy report, she died from an overdose of fentanyl. Mr. Boyd has correctly pointed out, we don't know, there's no video evidence, there's no eyewitnesses showing his client was there. I would submit to the court that people don't do drugs out in public. They do them clandestine and out of the public purview. And so it is very difficult to get evidence, not going to be video evidence of him arriving with a package. But we are dealing with the probable cause standard here. And the probable cause standard from the witnesses show the conversation that occurred. And then it's a bit corroborating when you look at the cell towers and they discuss, I'm at Meyer, and we can see the plotting of Claire from Meyer back home, and that Philippe Sotelo is then traveling to the cell tower where 529 Howe is in the same part of the city, and that cell tower they're both in. I think enough for probable cause purposes to bind the case over. It's clear that Claire was asking Philippe Sotelo for something. The records are in evidence showing whose phones are what, and for the court to base its decision on as a probable cause standard, I would ask the court to bind over. Obviously, the habitual offender's second notice would just follow count one. Thank you.
Your Honor, well, the government has established a tragic death and some circumstantial digital communications. They have not shown that a delivery occurred, nor that such delivery was the cause of death. Detective McCoggan established that no drugs, packaging, physical evidence tied the defendant to the scene, and that the alleged baggie was never recovered. This eliminates proof of delivery, Judge. Terry Redding confirmed that the decedent was with him most of the evening, that no one was observed delivering drugs, and that she had a known heroin history with recent incarceration and independent and intervening cause of overdose, Judge. Cocaine in the tox report. You can't just exclude that. That's a factor that must be considered.
When you say you can't exclude that, what do you mean? I mean, we know that the tox report says that there was cocaine present, but it's not saying that that was the cause of.
I'm not alleging, Judge.
Okay, so I'm trying to understand what you're saying. We can't exclude it for what purpose?
I'm not alleging, Judge, that the cocaine was the cause or that the cannabinoids was the cause. What I'm alleging, Judge, is that the people can't show that if Mr. Sotelo was to have been the person that delivered something,
it could have been cocaine.
It could have been any of those things that were listed in that tox.
Which would make it a question of fact. Correct?
No, I think it would make it an inference, Judge, but the court could exercise its discretion into how the court chooses to see those pieces of evidence.
If the people are able to show that Mr. Sotelo was delivering something, at least to a probable cause standard, but they can't show what he was delivering, that makes it a question of fact for the jury.
That would be accurate if they were able to show that he delivered something. They don't have, there's no evidence on this record to show that Mr. Sotelo arrived at that home at 529 and entered that home nor delivered anything to this judge. Thank you.
Today was a date and time set for a preliminary examination for control or delivery of controlled substance causing death. The burden is squarely upon the prosecution at this stage. It's for them to prove probable cause. It's a low burden. This is not a trial. They don't have to prove each element beyond a reasonable doubt. They only need to establish more than mere suspicion that the elements presented here are supported. And so it says here in the criminal jury instructions that the people would need to show, at least to a probable cause standard, that first the defendant delivered a controlled substance to another person. Delivery means that the defendant transferred the substance to another person knowing that it was a controlled substance and intending to transfer it to that person. Second, that the substance delivered was a controlled substance. Third, that the defendant knew he was delivering a controlled substance. Fourth, that the controlled substance was consumed by, in this case, Miss Claire McCray. And then fifth, that consuming the controlled substance caused Miss McCrae's death. And so we had a number of exhibits submitted, and then we had testimony of multiple witnesses. First witness being Terry Redding, who states that that he resides at the address of 529 West Howe Ave, which is in the city of Lansing, Ingham County, which makes venue in this court appropriate. He states that he was familiar with the victim in this matter, Miss Claire McCrae, and that he had known her for some time, met her at a bar that she worked at. He had provided a place for her to stay. He described in limited detail the home that he owned to be, I think, a 3-family or 3-unit home, and that he lived in a separate unit than the victim in this particular case, or the alleged victim. He said that she had just gotten out of jail, that they had spent the larger portion of the afternoon. It sounds like between maybe noon up until about 8 or 9 o'clock. He was helping her with some things. Sounds like they were running some errands all day. It was later determined that she didn't, it sounds like she didn't have a vehicle, but that he had taken her to pick up some mail and then taken her to Meyer to get some money from Western Union. And he testified that he then left after returning home and leaving Claire there, that he left and went to, I believe he said it was Center Stage, which I believe is where he alleged that he met Miss McCrae to have a beer. There is some question as to whether or not he was being honest about how much time he was away from the home, but he was pretty consistent, at least today, that he never told or indicated that it had been 10 minutes that he had left, that he was gone for at least 45 minutes to an hour, that he went to have a beer, that he didn't go back to the store. His testimony today appeared very credible as it relates to what he was doing during that time. He said when he left the home and left Claire, he didn't notice anything unusual about her, but when he returned, he was on the phone, I believe, with her mother, and that he said he noticed, I guess, based on the position in which she appeared to be sleeping or laying in the living room, he went to investigate or see what was going on and found her body to be stiff, and he believed her to be dead. He called 911. 911 was dispatched paramedics, and he indicated that her veins were purple, she was stiff, that there was some paper packet that was sealed in plastic that he noticed on the dresser, but that paper package was no longer there after the paramedics had left. It's unclear if he actually mentioned it to officers during the investigation. I think on cross-examination, he did mention something to the effect that he asked what happened to that paper package that was on the dresser. We did hear testimony from multiple analysts who pulled data or extracted data as part of providing investigative reports and support for cell phone data, and I believe also some meta, or basically both cell phone extractions. And the court is in receipt of exhibits, people's exhibits 4, people's exhibits 2, which I think is broken down. I have 2D and 2B, and I think I mixed one of them up. People's exhibit 3, which is a overdose report that was mapped through one of the analysts that testified today, the Detective Johnson. And in her testimony, she described towers and cell phone interaction, and how her report would serve to demonstrate how the cell phone numbers that were associated, or later through testimony associated with both the alleged victim, at least in her report, were what towers they would hit, showing, I guess, the location she would have been traveling. We also had testimony from another analyst, also describing cell phone extraction and a mapping that was done. We have then testimony by Detective Martha McGonigal, who was the lead investigator on this case. And she testified that there were search warrants that were submitted, and through those search warrants, they retrieved some data from Facebook accounts. One identified to be the Facebook account of the defendant in this court, Felipe Sotelo, and the other having been associated with Claire McCrae. It was interesting in one of the exhibits, that being People's 2B, during the testimony of the detective, there was an indication about some information that was, I guess, deleted or removed, and the time frame that was removed, I think, is a peculiar time frame, having been on the June 2nd, 2022, which would have been one day after the alleged incident in question. Again, this incident having occurred on about June 1st, 2022. People's Exhibit 4A, which the detective read into the record, reflects a conversation between two cell phone numbers that were identified as being one, the cell phone number of the deceased, and the other communicator being cell phone identified in another exhibit as belonging to Mr. Sotelo. And in that conversation, there is a text message that was sent from Claire, because it say, hey, it's Claire. And immediately another text message saying, you got any? It should also be stated that during the time frames of this, which is around 8/19, those time frames are pretty consistent with what Mr. Redding testified about the time that he probably would have been taking her back from Meyer back to the house. And he did make reference to whoever she was texting would be the only person that potentially knew where she was staying. But nonetheless, there is a text that says, hey, you got any? This is clear. Doesn't say what the any is, but the respondent doesn't need to know what it is. They said, yeah, how much? The person identified as Claire says, I'm around people who can't know I'm getting you. This is information that corroborates portions of Mr. Redding's testimony, which is that he had kicked her out 6 months prior for the use of illicit substances, and that she was not supposed to be using any of that while at his house. I think the court, based on the court's experience, can understand, based on this communication, that there is a exchange of some product that Miss Claire doesn't want people to know that she's getting, and that she's got 50. To which the person identified as Mr. Sotelo said, okay, we're WIA, which is where you at. She gives an address. He says he's on his way. Again, the time frame still being consistent with the time that the first witness, Mr. Redding, said that they would have been traveling back to the address, his address, 529 West Howe. There is a text message at about 8:29 that just says, I'm sorry, 8:29, that says 10 minutes, be ready. And then the last text message being, oh, okay, I'm on my way back from Lake Lansing Meyer, so I'm not even 10 minutes away. Again, corroborating the time frame. The argument of the defense is that there is insufficient evidence to demonstrate that Mr. Sotelo, based on this communication or any other evidence, delivered, in fact, any controlled substance. And if he did deliver, or if there was evidence to show that he delivered controlled substance, that it would be the controlled substance that was the cause, at least according to the toxology report of the death. Now, if the court disagrees, I think we can make a determination based off circumstantial evidence. And so when I have a communication here that makes it clear to me based off reading it that there's some kind of drug or illicit drug exchange, I believe that there was a communication and an arrangement by the person whose number is later determined to be owned by Mr. Felipe Sotelo and the person who's deceased now, Ms. McCray, and that they were going to meet up to exchange $50 worth of something that, or some substance that people were not supposed to know she had. What that substance is, the court can't determine. I think that's a question of fact, but I do believe that there was an arrangement that was made to make that exchange, and that based on the text message and based on the extraction mapping, that there was enough evidence to support probable cause that after these text messages, Mr. Sotelo traveled at least in that direction of 529 West Howe. And then shortly thereafter, because again, we have Mr. Redding only being gone for about 45 minutes to an hour, he returns to find Ms. McCray deceased. So the court is satisfied that there has been sufficient evidence to support each element of probable cause for delivery of a controlled substance causing death. This matter will be bound over as charged. The bind over date is going to be February 11th. That's the date the circuit court is receiving this file, not a date you need to appear in the circuit court, okay? Your next court date will be a pre-trial. Your attorney will be made aware of that date, okay? Do you have any questions at this time, sir?
Come in.
Bond was set at $50,000, 10% with GPS tether. I don't have any reason to address bond. I've not heard of any particular violations that will continue. Any additional matters for the record?
Just when the court's ready, may I quote you get the exhibits?
I am ready.
Thank you.
Thank you.
I'll also need to sign the transcript. Thank you, Judge.
Thank you.
Do you want a transcript?
Hello?
Hello?
Can you hear me?
Yeah, I can. Hi.
Don't know what's going on.
Let me do this, G.
On the record in the matter of Orbit Leasing Inc. versus Zyra Davidson, 13-03825. Have appearances, please.
Good afternoon, Your Honor. Jeremy Chisholms, P74670. I'm the attorney of record for the plaintiff.
Okay, Zyra Davidson is present via Zoom. Please state your name. Can you hear me? You're
Yes,
muted.
ma'am.
Okay.
Zyra Davidson. Zyra Davidson.
Thank you. Today was the date scheduled for a hearing. This is for an objection to installment payment order. Ms. Davidson, you have requested installment payment order where you're requesting to make a payment of $25 every 2 weeks, which would have began for your request on the 25th of this month. The plaintiff has objected to your request, indicating, A, this is the judgment that was entered well over a decade ago, November 19, 2013, the amount of $8,782.91 for a current balance, says the current balance is $1,564.21. He previously had an installment payment order back in 2022 of $75 per month, and you were not compliant with that order. And so that order had to be set aside. And now you're asking for a payment plan of $25 bi-weekly, which would be about $50 a month. Is that
Yes,
accurate?
ma'am. Yes, ma'am. I
Right.
was laid off at that time and I didn't have a phone, which I should have gotten in contact with them to let them know I was laid off, but my job did call me back to work and I am back working at my job now. But
You were
my
laid off
bills are,
for 4 years?
no, ma'am. I was laid off for a year and a half. For 4 years, I wasn't
Okay.
4 years behind. Once I
Well,
start,
this installment pay, when was the installment payment order set aside, counsel?
Judge,
I should, go ahead. I'm sorry. I apologize.
I,
It should be like maybe 4 or 5 months behind, not years behind. It's not even
there's,
a year behind.
there were payments.
Oh, okay. The installment payment order looked like it was set aside in December 2025, so just past December, correct?
Recently, Judge, it's hard. They didn't send me the order on the set aside. I've got a payment history that shows, um, payments in January, March, April, June, July, August, October twice of 2024. The last payments were received in January of 2025. There were two payments, one on the 17th and one on the 31st of January of 2025, each for $75.
Okay, it looks like the installment payment order wasn't set aside until December 15th of 2025, so about a month ago.
And at that time, it would have been because the sporadic nature of the payments. Some, there were some months that looked like they were doubled up here. There were some months that were missed. So I'm not exactly sure what it was at the time. Ultimately, I think the plaintiff's primary concern here is that, as the court's already mentioned, that this is over 12 years old at this point. The plaintiff has very graciously, I think, not assessed any interest on this account. And obviously that has, got us into the situation where these, low payments have chipped away at the principal to the point where we're down, to just a little over $1,500 remaining on it. So I think the plaintiff's primary concern here is obviously, one is that just to make sure that it's complied with going forward, but the two, that waiting another, 2.5+ years to get this taken care of, is, I don't think reasonable given the history of the account to date.
Thank you. Ms. Davidson, you're employed, you said?
Yes, and I do disagree because I was paying my payments on time. I just fell off a couple months behind. Other than that, they were being paid on time, and I think I did pretty good. Sorry.
Ma'am, it says you were past due $950.
Well, I thought it was 625, and then last month.
Even if it's the 625, then that's not you. That you're only, if payments were only $75 a month, so it's several months behind, and they've not gotten any communication from you. You've not come up to the court and filed any motion to amend the installment payment order. You just went ghost, made no payments.
And I did last month. I gave them $25 before, once this thing even got. Once I got the paperwork of coming to court, I did try to give them $25 last month. I did pay $25 last month or the month. Yeah, I believe it was last month.
Your order was to pay $75, and you had not gotten that amended, though, ma'am. That's the issue?
That's correct. I wasn't work. Yeah, you're right. Go ahead. I'm sorry for cutting you off.
Where are you employed?
At Extend Your Reach.
Okay, I think I see that here.
Yes, ma'am.
And you're saying, okay, you're only bringing home $2,000 a month?
No, I don't bring $2,000 a month. I bring probably $1,000 a month, or maybe $1,100 at the most after taxes.
Well, what you filed says my average income is $1,000 every 2 weeks.
Oh, I'm sorry. You're correct. A month. I'm sorry.
Okay.
Thinking of a week. Yes, you're right. I'm sorry. I apologize.
Okay, and then you say you pay your rent, mortgage, you have a utility bill, and then a car.
A car note and insurance.
Okay, I don't know that you listed insurance unless that's included in the car note, but I don't see that here.
I apologize. I do have the paperwork for it. for my
And so
insurance.
what has changed in your finances that you can't go back to the $75?
Well, I'm still behind in some bills, but I mean, I can try to go back to the 75. I don't
So you're
want to try.
behind from when you were laid off, is what you're saying.
Yes, I am. I'm
Got
still
it. So
behind in my car note.
you wanna do $25, you can get caught up on some bills.
Yes, ma'am.
Okay, and how long do you think it's gonna take you to get caught up on your bills?
I'll just say a couple months, maybe a month or two, try to get everything together, and then I can get back to my $75 a payment.
That's what I'm gonna order, that I'm gonna order that you can make payments of $25 a month for the next 3 months, and then you're gonna go back to $75 per month, okay?
Yes, ma'am.
I'm sure you wanna get this behind you, and you're really close.
Yes, I do.
Yeah, considering where you started, it is very gracious. If you would have known what this balance would have been if they had have attached interest, it wouldn't have moved. So because they didn't attach interest, it's really to your benefit, ma'am. So if I were you, I would go ahead and get this behind me as soon as I could.
Yes, I am. I plan to. I really do, and I appreciate them working with me and the patients. But yes, I do want this behind me because
Okay,
it's a lot. It's a lot.
I'm gonna enter an order again that she'll pay $25 per month. You're supposed to make a payment this week, or the 25th, is that correct?
Yes, ma'am, and I can make that $25 payment this month. Well, the 25th of February or January. I can make it today. Either way it go, I can make 25 today.
Your request was for you to start making those payments on the 25th of this month. So I am gonna order that you make a payment this week.
Oh, okay, I definitely can.
So January, February, March, you'll be paying $25, and in April, you'll go back to $75.
Yes, ma'am.
Okay, do you have any questions at this time?
Nope.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
Thank you, you're all set.
Have a great
Thanks.
day.
Have a great day. Thank you.
You too.
Bye-bye.
No, it's not letting me put it over. Let's see. Okay. Okay, this is the matter of Midland Credit Management versus Ari Bailey, 25-05724. Appearance, please.
Good afternoon, Your Honor. Matthew Kuipers on behalf of the plaintiff.
Okay, and is Iris Bailey present?
Hi, yes, I'm here.
Okay, today was the date that was scheduled for an objection to an income tax garnishment that you filed, Ms. Bailey, and the court is in receipt of. You filed this objection, and per the court rule is very specific about what grounds qualify for an objection to a garnishment. You stated that you have an installment payment order that was issued on April 3rd of 2025, and you list the case number, to which the plaintiff has responded, because this is about a garnishment for income tax, which you have not listed a valid objection for an income tax garnishment, ma'am.
Okay, I understand.
And so I'm happy to have you and the plaintiff go into a private meeting room if you want to discuss another way to avoid that, but the garnishment is properly issued, and you have not provided the court with a valid reason why your income tax could not be garnished to go towards the balance. But again, it's up to you and the plaintiff if you want to come to another arrangement with that, okay?
Yes, I'd like to take that opportunity. Thank you.
Okay, counsel, can I put you all in a private meeting room?
Sure, that's fine.
Okay, for the record, I do have to deny her objections.
Thank you. So there's no need to come back on the record. If we do come to an agreement, we'll just let the court know later.
I'm sorry, I couldn't hear you.
Yeah, if you come to an agreement, you'll just let me know.
Yep, sounds good.
Thank you.
Thank you.
The bench trial was already taken care of. That's good. I think they asked to be on the record to put terms. This is stiff to dismiss in the file. Yeah. Okay, Bank of America versus Deborah Petrelli. I have 25-03903, counsel appearance.
Good morning, Your Honor. Sandra Francis on behalf of the plaintiff.
Good morning, good afternoon, Your Honor. James Syke, P80407 on behalf of the defendant, Deborah Petrilli.
Okay, thank you. Today was the date that was scheduled originally for a non-jury trial, and there was also a motion for summary disposition that was to be addressed today. The court was advised that this matter was resolved and that a stipulated order to dismiss was uploaded. The court is in possession of that. Were you looking to put terms on the record?
Your Honor, the parties have agreed to enter into a conditional dismissal. The defendant has agreed to pay $282 on or before February 6th and $266 on the 6th of each month thereafter until paid in full.
And that's complete and accurate, counsel?
It is, but the settlement amount, if you could just
Oh, I apologize. Let's see here, $6,400.
That's correct, Your Honor.
Okay, I do see that here. I do have the order. I'll sign and date it for to date, and that will resolve this matter. Any additional matters for today's record?
No, Judge, thank you.
Nothing for defendant. Thank you, Your Honor. Thank you, Counselor.
Thank you.
Thank you.
Thank you.
Have a good day.
You too. Diamond Richardson versus Motor Cars of Lansing is 25-06115.
Good afternoon, Your Honor. Attorney Marcus Baldori on behalf of Motor Cars of Lansing.
Thank you. And your name, ma'am?
Diamond Richardson.
Okay, thank you. And this was a date that was scheduled. This is for a motion to set aside default judgment. And in this particular case, it was Motor Cars of Lansing who failed to appear and respond. Counsel, you would need to provide the court with good cause and a meritorious defense.
Yes, Your Honor, I appreciate that. This was actually a matter where Attorney Michael Mataloni had been hired by the defendant, and sadly, Mr. Mataloni passed away in December. I can't, he's not with us. I can't speak to really the timeline and what happened, but he passed away in December. That's when the default was entered. Defendant's, owner contacted me. I immediately filed this motion to set aside good cause. We'd like to litigate this on the merits. Vehicle is sold as is. That's something that can be established later down the line. But in terms of good cause, I think the default really is the result of the health issues and what was going on with Mr. Mataloni at the time, unfortunately.
Well, some of the information you're providing is not accurate, sir, because although Mr. Mataloni did in fact pass away in December, the default was entered in November. Mr. Mataloni was appearing in our court around that time and in the month of November. He passed away suddenly, had not been missing court prior to that. So it's unclear why, after being served with this, it looks like proof of service was in October. Again, Mr. Mataloni was before me multiple times in both the month of October and November. But there was no default. There was no default entered until November. Mr. Mataloni still was alive during that time, and apparently on this case, there was not a motion to set aside this until the 22nd of December.
And if Your Honor, I filed.
And you don't have a good connection. Your connection is not good. I don't know what you're saying.
I'm sorry, Your Honor. I can try to get to a better spot. I don't know if that's any better.
That's a little better, but you might even need to stop your camera. It sometimes helps the connection.
Okay, we'll see if that helps it. I'll try to get up and speak more clearly. And if I wrote the wrong date of the default, I apologize for that. I thought what I see written on the motion is December 2nd. And the truth is, Your Honor, I can't really speak to what happened with Mr. Mataloni and why there was a default. He can't speak to that. I can't speak to that. I know that my clients told me that he was trying to get Mike to, respond to this and answer. I really don't know what happened. I wish I could give the court information about that. I know as soon as he contacted me, I filed this the next day. So I apologize to the court that's the what happened. I don't know.
Okay, and I recognize it's outside of your control because you were not the one, nor did you work for Mataloni's office. Ma'am, did you want to respond?
Yeah. Without rehashing this entire case, I will begin with my objection to any change in the judgment.
Can you speak up a little bit, ma'am, or just get closer to the? It doesn't amplify your voice, but at least she can pick up what you're saying.
I was thinking of filing an additional complaint for motor cars, calling the LPD and reporting my car abandoned, and I never abandoned my car, and they towed it on the very day they were served. This just goes to show how bad their business practices are, or the fact that they knew the car was junk. As noted in my complaint, I didn't have the car I purchased from them 90 days before it was totally out of commission, needing major engine work. But prior to that, I did take care of 4 issues within the first month and a half of owning the car. First, on June 19th, I had to disperse $438 to Affordable Tires for 2 tires. This was not expected so soon, but I conceded to the replacement. Second, on July 3rd, I had to disperse $34 to remove and replace the stabilizer and bar end link to motor cars. 3rd, on July 8th, I had to disperse $230 to repair the non-working air conditioner to motor cards. Additionally, on July 17th, I had to disperse another $312 to replace the air compressor with Motor Cars Atlantic. Please note in the receipt, it indicates it was replaced with the used part from Schroyer's garage. I wonder why this wasn't noticed or disclosed during the July visit. Finally, and the most egregious of all is the fact that the car is now inoperable and needs a new engine. I was quoted on August 11th, $5,681, of which I'm being told I must pay $1,800 in less than 90 days. I have paid $1,000 and $1,015.92